defense rests, let's lay it down. Gonna dig deep, wave that verdict round. The defense rests, time to analyze. With the evidence, we'll unveil the crime. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Mr. Wilson, at this time, then? Can you raise your right hand, please? You swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Wilson, head right over there, if you would, please. Okay, go ahead, Mr. Brown.
Mr. Wilson, good morning. Good morning. Can you please state your name for the record? Nick Wilson. And can you tell us where you live? Brooklyn, Iowa. How long have you lived in Brooklyn, Iowa? Since I was 5. Okay, so you grew up there? Yes. Went to high school there? Yes. All right, when did you graduate high school? 2010. Are you employed? Yes. Where do you work? Jasper Construction. And what type of work does Jasper Construction do? Bridge construction and repair. I forgot to ask you, are you married? Yes. Do you have children? 1. How long have you been married? Just a little over a year. All right, Jasper Construction, that's, how long did you worked there, did you say? 10 years. And what type of work does Jasper Construction do? Bridge construction. And does your work take you on the road? Yes, it does. Typically, do you work in the state of Iowa? Yes, typically. And whenever it takes you on the road, is it usually for a week or 4 or 5 days of a work week? Yes, we're usually home every weekend. And do you work long days? When we're on the road, especially, yes. I assume bridge construction is hard work. Is that right? Pretty manual, yes. Mr. Wilson, do you know Dalton Jack? Yes, I do. How long have you known him? 5 years. And did Dalton Jack ever work for Jasper Construction? Yes, he did. And did he work in the summer of 2018? Was he working for Jasper Construction? Yes, he was. And was he a good worker? Very good. Showed up on time? Yes. Never had any real problems with him? Nope. Did you know Dalton Jack outside of work with Jasper Construction? Just at hotel, when hanging out with him, yeah, just a little bit. Not personally, but yes. You're a little older than him, is that correct? Correct. All right, I want to direct your attention, Mr. Wilson, back to the week that includes Wednesday, July 18th of 2018. Do you recall that week? Yes, I do. Was that the week that Mollie Tibbetts went missing? Yes. Is that why you can remember that week a little bit better than others? Mm-hmm. Is that a yes? Yes. Sorry. All right. So tell me, when did the job start what job were you working the week that included July 18th of 2018? Well, that Monday we started on a job we had to do. It was in Amana. It was probably 5 minutes east of Williamsburg. And then that following Tuesday, we were up in Dubuque, and that's when we started staying in the hotel. And we got in Dubuque at 6 o'clock that Tuesday, and worked till 5 o'clock. And then that Tuesday, we would go get groceries for grilling and everything like that. Then okay. Wednesday. Hang on just a second. You're getting just a bit ahead of me. Okay. Let's talk about that work week that includes July 18th. So 2 days before, on July 16th of 2018, was your crew working in Iowa County? Yes. You said near the Amana colonies? Yes. And did Dalton Jack, was he included on that crew? Yes, he was. All right. Was that just a one-day job? No, it was a job I was doing in the meantime while crews were doing removals on the Dubuque job. So we had to wait for them to do the removals. And then once they had the removals done, we were going up there to form up to report. Okay. So one day in Iowa County? Yes, Monday. And then did your crew that included Dalton Jack then move to Dubuque? Yes. And what was the job there? Specifically, where was it located? On Highway 61, right before going over into Wisconsin. And explain the type of work that you do on bridges like the one that goes over Highway 61 near Dubuque. Well, we would break all the way through the bridge deck, and they have joints in the bridge that allow the bridge to move. And we had to replace those joints. So we'd bust them out. We'd reform up underneath of it, place a new joint in there, and then pour concrete all around the joint to hold it in place. And on Tuesday, July 17th, Wednesday, July 18th, and Thursday, July 19th, was Dalton Jack working with you in the city of Dubuque on the job you just described? Yes, he was. Have you had it, or did I ask you to go back and look at employment pay sheets to verify hours and the presence of other crew members?
Yes, you did.
Did that help refresh your memory?
Yes, it did.
And let's talk about Wednesday, July 18th of 2018. Do you remember that particular day?
Yes, I do.
All the way also is that week is particularly memorable to you for another reason?
No.
Okay. Is it the week that Mollie Tibbetts went missing?
Yes.
Okay. So does that help you remember?
Yes, it does.
Okay.
Yes.
I may have already asked you that. Now, going back to Wednesday, July 18th of 2018, was Dalton Jack on the crew that was working in Dubuque on the bridge that crossed the river?
Yes, he was.
And on Wednesday of July 18th of 2018, what were Dalton Jack's hours?
Objection, calling for hearsay.
Overruled. Witness may answer.
5:30 a.m. to 7 p.m.
Whenever a particular, by the way, this crew that you're working, are you in a supervisory position?
Yes.
Do you log their hours for them, the men on your crew?
Yes, I do.
They don't have anything to do with that themselves?
No, they do not.
Do you create a timesheet that reflects the hours that each crew member worked?
Yes, I do.
And how long did Dalton Jack work specifically on July 18th of 2018?
12.5 hours.
He worked till 7 p.m.?
Correct.
Were you and the other crew members staying at a motel near Dubuque?
Yes, it was a Days Inn in Dubuque.
And how far was the Days Inn from the job site that you described to us?
10 minutes.
And did you and your crew, including Dalton Jack, go anywhere after work at 7 p.m. on July 18th of 2018?
No, we did not.
Did you go back to the hotel?
Yes.
All right. And did Dalton Jack go with you?
Yes, he did.
Did you see him at the Days Inn after 7 p.m. on July 18th of 2018?
Yes, I did.
So what was the plan then after work for July 18th of 2018 for you and your crew?
We usually go back to the hotel, get showered up, then bring our food out. We all have one grill and we all just grill at the same grill and have a couple beers, play bags, and then usually go to bed decent time so we can get up, work a good day tomorrow.
And did you do that on July 18th of 2018?
Yes.
And was Dalton Jack present for the grilling?
Yes,
And did he play bags?
he did.
Did you ever see him go back to his room? Do you ever recall that?
No.
On July 19th of 2018, what was the plan for the workday?
Well, we started at 5:30 that day. We knew rain was coming, so we were just trying to put in a good day before the rain hit. So we worked through lunch and we stopped at 2 o'clock that day. And then after that, we called it, we waited out rain for about half an hour, and then we'll call the day. And then we went back to the hotel and we stayed at the hotel because we're going to work the next Friday anyways.
And was Dalton Jack present for the workday on Thursday, July 19th of 2018?
Yes, he was.
As far as you know, was he there the entire time from 5:30 a.m. to 2 p.m.?
Yes.
By the way, did he have a specific job on your crew?
He would just be considered a laborer.
Did you notice anything unusual with Dalton Jack's demeanor, how he was acting on July 19th of 2018?
Yes.
And can you describe that, please?
He was acting kind of down, not really speaking with his, the group, and just kind of sad.
And did he ever express to you what was causing him to be sad?
Later on that day, yes, he did.
What did he say?
He told me that he hadn't spoke to Mollie in 18 hours and he was getting worried and nobody had heard from her, none of the friends he contacted. And he was going to maybe leave that night to go put a missing person report at the 24-hour mark and told me that he might not be at work the next Friday.
Was that okay with you?
Yes, it was.
Okay, were you worried for him?
Yes, I was.
And did Dalton Jack come to work then on Friday, July 20th of 2018?
No, he did not.
To your knowledge, did he go back to Brooklyn?
Yes.
Did you and the rest of the crew finish out your job on Friday?
The rest of the crew did. I left a little early to go help search
Go help search for who?
for Mollie.
And when did you do that?
I did that probably 9 o'clock in the morning on Friday. I called my boss, asked him if I could leave and come help because he has property in Brooklyn, farm, ground, and everything. And he said that was fine.
And did you drive back to Brooklyn?
Yes.
Is it about from the bridge to back to Brooklyn, is it about a little over 2 hours?
Yes.
And when I would say that, a 2-hour drive or a little more?
Yep.
right, that's all I have. Thank you.
Defense may cross-examine.
Sir, you were in Brooklyn helping with the search, is that right?
Correct.
I haven't seen any records of you being interviewed. Do you recall if you were ever interviewed originally?
I was just interviewed by the FBI agent. I do not remember his name. He called me. I didn't get interviewed in person, but it was a cell phone call.
All right, so you were called by an FBI agent, is that
Yes.
correct?
Yep.
How long did that call last?
It lasted maybe a matter of 3 minutes, maybe.
What was the call regarding?
Just Dalton's whereabouts.
Now, you were not originally subpoenaed as a witness to testify at this trial, is that correct?
Objective calls, it's not relevant as to when we call him.
Overruled.
You were not subpoenaed, is that right?
Correct.
When were you contacted about testifying at this trial?
Actually, a couple weeks beforehand by a sheriff
All right, and what was your understanding of the reason for the call?
to give Dalton an alibi, technically, yes.
So you were called by the sheriff to give Dalton an alibi, is that right?
Well, yeah, I was the only witness there for him, pretty much other than the crew.
Were you ever asked to produce these records that you relied on?
Later on, yes.
So just recently, is that right?
I offered to bring him beforehand, but
But-
then he asked me to bring him once. Yes, later on.
All right, so originally when this investigation was going on in 2018, were you ever asked to produce records?
No,
So the records that you've relied on, you've just looked at in the last couple of weeks, is that right?
correct.
Sir, there's been some talk about you drinking most of the day, that you were rained out on Thursday, July 19th of 2018. You recall drinking that day?
Yes,
And specifically, it was asked if you needed to have a ride to the store because you were so intoxicated.
it's not correct. I had a company vehicle and I was following the law,
Which is what?
which is you cannot drink and drive.
So you asked for someone else's assistance on July 19th to get to the store, is that right?
Correct.
Specifically, who was that?
Dalton, Jack.
And that was because you were not in a condition to drive, is that correct?
That's because I would not be able to pass a breathalyzer, correct?
Now, it's customary for crews to drink after a long day of work, isn't that right?
Correct.
So pretty much any day that you are working, you are also consuming alcohol later on that night, is that right?
No,
Most nights?
no,
Well, let's talk about Wednesday, July 18th of 2018. You said that you drank a couple of beers that night, isn't that right?
correct.
Now, if Dalton Jack originally said to law enforcement that he showered that night and watched Rush Hour 1 in his room, would you disagree with that statement?
I'm not objective. She's asking this witness to comment on another witness's credibility.
No, the witness can answer if he knows.
Well, I do not recall.
So you're not sure if he was in his room?
It's hard to remember. It was 3 years ago.
You just testified that you were out playing yard games and grilling, isn't that right?
Correct.
And that Dalton was there.
Correct.
But you're telling us that if Dalton said that he actually showered and watched Rush Hour 1 in his room, that you're not sure if that happened?
No. How would I be sure if he was in his room watching Rush Hour? He could have done that during the shower, had it on, played it, then came outside.
Dalton Jack was interviewed several times when this originally happened. You knew that, is that right?
Correct.
And his recollection within days of this happening, you'd agree that would be better than yours 3 years later.
Correct.
Workers at your company routinely share rooms, isn't that right?
Correct.
And in this case, are you aware that Dalton Jack was sharing a room with Brandon Gordy?
Yes.
Now, Brandon Gordy would be a better person to say where Dalton Jack was in the evening hours of July 18th of 2018. Isn't that
I'm
right?
going to object. This calls for speculation as to what Brandon Gordy may have said or seen or heard.
Sustained.
You'd agree with me that you go to sleep early so that you can start the day early. Isn't that right?
Yes.
And Brandon Gordy would be the person that is in the room with Dalton Jack that night.
Yes.
You were aware that Mollie Tibbetts and Dalton Jack were having problems with their relationship. Isn't that right?
Objections exceeds the scope of direct, calls for speculation.
overruled, the witness may answer if he knows.
Not at the time, no.
You found out after the fact?
I found out during the trial.
No further questions.
Mr. Brown, anything else of this witness?
No.
Okay, sir, thank you for being here. You're excused.
Thank you.
Mr. Brown, does the state have any other rebuttal?
No further rebuttal witnesses, Your Honor. State of Iowa rests.
Okay, members of the jury, here's where we are with things. Both sides have rested. We're going to take a, let's say, 10 to 15-minute recess. We'll be back as quickly as we can. I want to remind you of your admonition. Leave your notebooks where they are. And just, again, kind of give you a sense of where we're headed here. When we come back from the break, I will read to you the jury instructions, which are the law for the case. After that, we'll go into closing arguments for each side. And after that, you'll begin your deliberations. So again, let's be in recess. Let's say 15 minutes to be safe. Thank you. And Carrie will, I think the instructions in the case. However, before I do so, I just want to mention to you, you are allowed to take notes as I read the instructions to you, as you have been allowed to do throughout the trial. However, I want you to be aware you will have the original, and each of you will have a copy of these instructions with you during deliberations. Members of the jury, the trial information charges the defendant, Cristhian Bahena Rivera, with the crime of murder in the first degree. The trial information includes the lesser crimes of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. You are instructed as follows. Instruction number 1. Cristhian Bahena Rivera has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 2. The trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 3. Cristhian Bahena Rivera is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 4. You shall base your verdict only upon the evidence and these instructions. Evidence is 1, testimony in person or by deposition. 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence. 1, statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything you saw or heard about this case outside the courtroom. Instruction number 5. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 6. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 7. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all the instructions together. No one instruction includes all of the applicable law. Instruction number 8. Nothing I have said or done during the trial was intended to give you any opinion as to the facts, proof, or what your verdict should be. Instruction number 9. The burden is on the state to prove Cristhian Bahena Rivera guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if after a full and fair consideration of all the evidence or lack of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Instruction number 10. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 11. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 12. Where 2 or more alternative theories are presented, or where 2 or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Instruction number 13. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and that he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 14. The state must prove all the following elements of murder in the first degree. 1. On or about the 18th day of July, 2018, the defendant stabbed Mollie Tibbetts. 2. Mollie Tibbetts died as a result of being stabbed. 3. The defendant acted with malice aforethought. 4. The defendant acted willfully, deliberately, premeditatively, and with a specific intent to kill Mollie Tibbetts. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree explained in instruction number 22. Instruction number 15. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 16. Deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 17. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 18. If a person has an opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 19. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Instruction number 20. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used, it is designed manner is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 21. Concerning element 2 of instruction number 14, the wound or wounds inflicted by the defendant resulted in the death of Mollie Tibbetts if it caused or directly contributed to Mollie Tibbetts' death. Instruction number 22. The state must prove all the following elements of murder in the second degree. 1. On or about the 18th day of July, 2018, the defendant stabbed Mollie Tibbetts. 2. Mollie Tibbetts died as a result of being stabbed. 3. The defendant acted with malice aforethought. If the state has proved all the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you shall then consider the charge of voluntary manslaughter explained in instruction number 24. Instruction number 23. Murder in the second degree does not require a specific intent to kill another person. Instruction number 24. The state must prove all the following elements of voluntary manslaughter. 1. On or about the 18th day of July, 2018, the defendant intentionally stabbed Mollie Tibbetts. 2. Mollie Tibbetts died as a result of being stabbed. 3. The stabbing was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you shall then consider the charge of involuntary manslaughter explained in instruction number 26. Instruction number 25. Concerning element 3 of instruction number 24, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring her passion under control and suppress the impulse to kill. Words alone, however, abusive or insulting, cannot be serious provocation. Instruction number 26. The state must prove all the following elements of involuntary manslaughter. 1. On or about the 18th day of July, 2018, the defendant recklessly stabbed Mollie Tibbetts. 2. The defendant did the act in a manner likely to cause death. 3. By doing the act, the defendant unintentionally caused the death of Mollie Tibbetts. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter. Instruction number 27. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining a defendant's specific intent requires you to decide what he was thinking when the act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to conclude a person intends the natural results of his acts. Instruction number 28. Evidence has been offered to show the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence, just as if they had been made at this trial. You may also use these statements to help you decide if you believe the defendant. You may disregard all or any part of the defendant's testimony if you find the statements were made and were inconsistent with the defendant's testimony given at trial, but you are not required to do so. Do not disregard the defendant's testimony if other evidence supports it or if you believe it for any other reason. Instruction number 29. The defendant cannot be convicted by a confession alone. There must be other evidence the defendant committed the crime. In determining the weight and believability of the confession, you should consider 1, the defendant's mental capacity and intelligence, 2, the defendant's mental and emotional state at the time it was made, 3, whether it was knowingly and intelligently made, 4, whether the defendant understood it, 5, any other evidence relating to the confession. Instruction number 30. Evidence has been received concerning the defendant's character for nonviolence. This evidence should be considered with all other evidence in determining whether the defendant is guilty or not. If you find the defendant's character as to nonviolence is good, you may consider this evidence in determining whether a person of such character of nonviolence would be likely to commit the crime charged. If the evidence of such good character as to nonviolence is good enough, together with all the other evidence, to raise a reasonable doubt as to the defendant's guilt, he must be acquitted, even though without such proof of good character, the jury would convict. However, the defendant's previous good character as to nonviolence is not a defense if you find by evidence beyond a reasonable doubt that the defendant committed the crime charged. Instruction number 31. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Instruction number 32. During the trial, you have been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and are not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. Instruction number 33. Smoking is prohibited in the jury room during deliberations. If a juror feels it necessary to smoke, the juror must leave the jury room and smoke in an area designated by the court attendant. During the juror's absence, the jury may not continue to deliberate, as all jurors must be present during deliberations. Instruction number 34. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that the deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement, if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of all the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of other jurors or for the mere purpose of returning a verdict. Remember, you are the judge of the facts. Your sole duty is to find the truth and do justice. Instruction number 35. Occasionally, after a jury retires to the jury room, the members have questions. I have prepared the instructions after carefully considering this case with the attorneys. I have tried to use language that is generally understandable. Usually, questions about instructions can be answered by carefully rereading them. If, however, any of you feel it necessary to ask a question, you must do so in writing and deliver the question to the court attendant. I cannot communicate with you without first discussing your question and potential answers with the parties and the attorneys. This process naturally takes time and deliberation before I can respond. When I respond, it will be in writing, and the foreperson must read the response to the jury. Keep the written question and the response and return it to open court with the verdict. The court attendant who has been working with me on this case is in the same position as I am. She will be taking an oath not to communicate with you except to ask if you have reached a verdict. Please do not put her on the spot by asking her questions about the case. Instruction number 36. I am giving you one verdict form. When you have agreed upon a unanimous verdict and the foreperson has signed the verdict form, please notify the court attendant. Signed this the 27th day of May, 2021, by myself, Joel D. Yates. Ladies and gentlemen, it is now the time and place for counsel for each side to present their closing arguments or summations of the evidence. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply, and since he will only address you once, he will also present his summation. Counsel for the state will then have his closing summation to the arguments of the defendant. The counsel for each party will be summarizing the testimony that you have heard and the evidence which has been presented during the trial. They will merely be recalling the evidence as you will later. They will not intentionally try to mislead you, and if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations of counsel are merely that, summations. They are not evidence, nor should they be construed by you as evidence or instructions on the law. The summations are intended to help you in your understanding the contentions of each side. Therefore, I would ask that you give the attorneys your full and complete attention at this time. Mr. Brown, on behalf of the state of Iowa, you may proceed.
Thank you, Your Honor. Screen up, please. May it please the court, counsel, Mr. and Ms. Reese. Good morning, ladies and gentlemen of the jury. This is a case that you have heard over the last few days here in this courtroom. You've heard a case and evidence about a young woman who went for a run on July 18th of 2018, and she never came home. Her life was brutally taken by the defendant on July 18th of 2018. This is Mollie Tibbetts, 20 years old, just starting out her adult life. Mollie Tibbetts went for a run. She'd have gone for a run most days. Sometimes she would go a short distance, sometimes she would go a little bit longer. But on July 18th of 2018, she went for that run that was a little bit longer. She was confronted by this man. She crossed paths with him, and it ended her life. She was attacked brutally by him. She was stabbed repeatedly by him. Can you imagine what that was like for her? 9 to 12 times she was stabbed. Her clothing was removed. She was dumped into a cornfield, discarded under a pile of corn. She was covered with those leaves, and she was left. 5 weeks, Mollie's body laid in that cornfield. And you know who knew about that? One man. One man knew, and he is here. His name is Cristhian Bahena Rivera. The evidence in this case shows that the defendant, and only the defendant, murdered Mollie Tibbetts. All of the credible evidence in this case, all of it. There weren't 2 other guys. That's a figment of his imagination. All of the credible evidence in this case, all of it points at him. All of it. All right. Judges read you instructions as to what the charge of murder in the first degree is. There are 4 elements, 4 things that the state has to prove beyond a reasonable doubt. That's what we have to show. What those 4 elements are, what the evidence is in this case that proves that Cristhian Bahena Rivera is the man who murdered Mollie Tibbetts and murdered her in the first degree. That's the evidence that we're going to talk about, the evidence that you've heard over the last few days here in this courtroom. That's what we're going to talk about here. But make no bones about it. This is what it is. This is what murder in the first degree is. This is the law. The state is required to prove each of those elements beyond a reasonable doubt. Are you firmly convinced? Whenever you look at this evidence, that's the question before you. Elements 2, 3, and 4, there is really no doubt about. All right, we'll talk about them as we go through this evidence more towards the end of my presentation here. But we have to prove them. We have to prove that Mollie Tibbetts died as a result of being stabbed. Of course, we have that evidence here. We have to prove 2 states of mind of the defendant, that the defendant acted with what's called malice of forethought. The judge has given you that definition. We'll talk about that just a bit later. And then the 4th element that we have to prove is that the defendant willfully, deliberately, premeditatedly, and with specific intent, he acted with that specific intent to kill Mollie Tibbetts. As this evidence has come in, as you have seen it, as you have heard it, there really is no dispute with these 3 elements, that whoever killed Mollie Tibbetts acted with malice of forethought and acted with those other states of mind in element number 4. Okay? You follow me? 2 through 4. We're going to talk here a bit about element number 1, which is really what we're going to spend most of our time talking about here this morning. And that first element is what I refer to as the identification element. That on or about the 18th day of July of 2018, the defendant stabbed Mollie Tibbetts. Right? That's what the evidence that we're going to talk about here. Was it the defendant? Was it Cristhian Bahena Rivera? Was it him? The basic story of what occurred that day will focus on this particular element. But what is the basic story of what happened on July 18th of 2018? What do we know from the evidence here, from the witnesses who have testified and come forward and taken the oath and sat in the witness chair and told you what happened? Mollie Tibbetts was 20 years old. She was a University of Iowa student. She had just finished her freshman year at the University of Iowa, and she had come home for the summer. She worked at a preschool at the hospital in Grinnell. She had a boyfriend named Dalton, and she was working at the job at Grinnell, and she was enjoying her summer. Right? She lived at a house at part of the time at 622 West Des Moines in Brooklyn, where Dalton lived with his brother Blake and his fiance at the time, Allie. They lived at that house. Mollie would frequent the house. Sometimes she would stay there. Sometimes she would stay with her mom. That's what the evidence is in this case. Mollie then went for a run, right? Like she did many times. Mollie went for a run on July 18th of 2018 at about a little bit before 7:45 p.m. You've heard testimony from people who knew her that said she liked to run in the evening. That was her preferred time to go out for a run. We've also seen through other witnesses in this case, and they've talked about what her routes were. Sometimes she would run around town. Sometimes she would run out on 385th. That's what she would do, right? She was a runner. She'd run cross country in high school and track, and this was one of the things that she enjoyed doing. It was on that night, on that evening of July 18th of 2018, that she ran across the defendant in his chrome-mirrored, chrome-handled, spoked-tired Malibu. And the evidence is in this case is that he stabbed her to death. Let's talk about that. This is what the issue here is. This is what this evidence will be focused on. Who killed Mollie Tibbetts? Who stabbed her? Who killed Mollie Tibbetts? Let's look at that evidence. First of all, well, let me tell you this before I get into this. Really, there's 3 components to the proof that we have here in this case. 1 is the surveillance video from Logan Collins's residence that was collected by DCI agents that puts Cristhian Bahena Rivera, the defendant, in the area, also puts Mollie in the area at the same time. So that's one component, that video. That's what broke this case open. That's what broke this case. That's what began to ID the defendant. So we have the video, the surveillance video from Logan Collins's residence. Right. The second thing is, whenever the defendant was interviewed, he confessed. He told Pamela Romero what he did. At least those parts that he claimed that he could remember. And then the third component to this case is the physical evidence. The blood of Mollie Tibbetts is found in the trunk of the black Chevy Malibu that the defendant was driving, that he owned, that he operated, that Airly Lorenzana bought for him. He's directly connected, really exclusively, to the black Chevy Malibu. So let's look first at the video evidence that we have here. The video IDs him. He's confessed. Sometimes I get ahead of myself. The DNA and the blood puts in there. Mollie's location and evidence surrounding her also corroborate the identification of the defendant because of the way in which she was found under the corn stalks, which he described without ever going back there with the officers later. So we have these components to the case, all of which, when you put them together, knit together a coherent story and prove beyond a reasonable doubt that the defendant is guilty. So let's look first at the video evidence. Let's review that and let's look about that. That's the first component I talked about, right? The video evidence that puts Mollie and the defendant together in the same area. This is an enhanced video that we have. Let's play it again. There she goes. Now, we look at the video. Can we say that's her? That's Mollie Tibbetts just by looking at it? Of course not. We have to look at all the evidence in the case collectively. The defendant puts her there for sure, but that's Mollie Tibbetts that's running on that video. So we now have her in the area. What time was that? On the video stamp of the video from Logan Collins's house, it was at 7:45 p.m. What do we see next? Within 30 seconds of Mollie passing through the video of what we just saw, we see that car. Look closely at this picture. We see it more than once. We have two other views of it. Actually, we have a fourth view of it, but we have these views here. This is Logan Collins actually on the left, standing in his yard. You can see the black Malibu on the left side, and you certainly can see it here on the right whenever it passes by again. So between the hours of 7:45 p.m. and 8:07 on the video, we see this Malibu pass through several times as Mollie is on her run. All right, this is the video that broke this case open. Agent Reeson was talking to you. So did Matt George yesterday. He was one of the team of DCI agents that was working on this case. And he and Agent Reeson were looking at it. I think it was Agent Reeson that looked away quickly, and Matt George saw the shadow of the jogger go by. But that's what broke this case open. Because remember, before this, what had the agents and the officers been doing? Right? They've been spending several weeks trying to figure out what happened to her. They've been spending several weeks trying to find her. They can't find her. Right? The corn is overhead tall in the fields. They're up against a pretty decent challenge. Law enforcement was here to find this young woman. They've been looking. They've been talking to other people, who we'll talk about here in just a few minutes. But they've been trying to figure out where she went, what she did. They had a little bit of help from the FBI, from Kevin Horan, in trying to locate an area to even search. But think about what they were up against. This is a young woman who really didn't have many enemies, if any. And I'm not sure there's any testimony that Mollie was disliked by anyone. She's a sweet young woman, right? She's what they called a low-risk victim. No drug history, no domestic violence, nothing of that nature, right? This was a tough one to crack, to figure out who was this? Who would do this to her, right? They looked at other people. But this video, when they had it, okay, a clue came in, a lead came in. Now they had a vehicle that they could associate with the area where Mollie would normally run and within very close proximity to when she passed through. This was the car, and this car belonged to Cristhian Bahena Rivera, the defendant. That's what got them there. Now, I want to break for just a second and talk about, just briefly, this man's testimony yesterday, right? All of a sudden now we have these two men, right? He gets up and gives us this different version of what happened. You know what the problem is with it? It doesn't make sense, and it doesn't fit. The video evidence here refutes his testimony. He said that he and two men passed her running going into town, right? Out on 385th. They were going into town whenever she was running. That's when he said they saw her. How in the video shows the defendant on East Des Moines seconds after she passes through, not out on the county road. Whoops, he didn't think about that. Right? We've got him in town, in his vehicle, whenever she passes by, within 30 seconds. Think about that. Right after she passes by, there is no way he could have passed her on the outskirts of town and seen her for the first time. He saw her for the first time whenever he saw her in town. That's what the video shows. He cannot be two places at once. It doesn't work. It doesn't work. Whenever he gets up on the stand and whenever he testifies and gives you this new story, these additional facts that he never told police, you can judge that the same as you do any other witness. You can scrutinize it. You can look at other evidence that we have in the case. And you know what it doesn't fit with? It doesn't fit with that video. Continuing about the video, what happened before the video was looked at and before they went out to the farm to talk to him. So they had the video, officers were looking at it, Agents Reeson and George, they passed that along to other officers in the case, right? They're trying to figure out, they don't know, whenever they see that video and see that car with those distinctive features, with the chrome mirror, with the chrome handles and the spoked wheels, they don't know that it belongs to Cristhian Bahena Rivera. They don't know that, right? They can't associate it. There's black Malibus. It's a common vehicle, right? So they're looking. They have a lead, and they're chasing it, and they're trying to figure out who is this person that is passing by in the area where Mollie Tibbetts is believed to be running. Who is it? We got to figure this out. Who is this person that keeps going by, right? Multiple times between 7:46 and 8:07. Who is this person? We got to try to figure this out. Well, they did. Steve Kitty, who's a police officer, is a deputy sheriff with the Poweshiek County Sheriff's Office, is driving August 14th, right? He's driving after this video has been seen. August 16th, I believe, is driving this video. And whenever he knows the information, he knows what the car looks like. And you know what he sees? He sees this vehicle. This is a picture taken from the night that he encountered the defendant in Malcolm. Remember, Malcolm is a town that is just north of I-80 in Poweshiek County. And Steve Kivy that evening sees this vehicle, and it's like zeroed in on it, right? Why? Because it has distinctive features. It has the chrome mirrors, chrome handles, the spoked wheels, but it was mainly those chrome mirrors that drew his attention, and it was black. And so he pulls, actually, if you recall the testimony, Officer Deputy Kivy was behind the Malibu whenever he was ahead of the Malibu whenever he pulled off of the road and then let it pass, and then followed it, got to an alleyway, used an interpreter, and he found this vehicle with those features. And who was driving? The defendant, by himself, alone. Had to use a resident there who spoke Spanish to try to communicate with him, asked him a few questions, denied anything. First story, by the way, that the defendant tells about anything about Mollie Tibbetts when he's asked, denies. Doesn't know anything about her. So now, police have a potential suspect in this man that you see here on the right. Is the same guy that's sitting here in the courtroom. The defendant admits he's the sole person who uses the Malibu, and then a plan is put together in order to try to take him in or bring him in and interview him to try to gain some information, right? The police still don't know. Is he connected? Maybe. His car's in the area. Now we know who it is. We need to talk to him. They're going to follow the evidence. They're going to follow the lead. So that's what they do. So the video here proves what? It proves the identity of the defendant, the vehicle that he's in. He later admits that was his car, and his proximity to Mollie Tibbetts. So the video and the admissions of the defendant place him in Brooklyn within seconds of Mollie's sighting that we saw on the video. So why is that important? It is important because he is in the area within seconds. It fits with the evidence in this case. It fits with him having the opportunity to see her, to notice her, right? You can look at the picture of Mollie Tibbetts. She is a cute 20-year-old young woman. He likes her. He sees her. She's in tight clothing as she's jogging. She's in a jogging bra and spandex type shorts as she's jogging down the road. That's what got his attention. That should be patently obvious. So the video, the first component that puts these two people, that puts the defendant together with Mollie Tibbetts, is the video. It's really irrefutable. And it is the thing, the piece of evidence, the lead that the police followed that broke this case and led them to more evidence and more evidence that the defendant was the one who committed Mollie Tibbetts' murder. So component number one. The second component to this is the interview of the defendant. Several days passed, there was a weekend in between, and officers made a plan. They got some help from federal partners in Homeland Security. They got other officers from DCI, and the plan was to go out to Yerby Farms and make an attempt to not only talk to the defendant, but talk to anybody else or make contact with anyone else who may have information or be a witness in this case, anybody that they can talk to. So they did. They found on August 20th, they found the defendant working. If you recall, what the evidence is in the case is that he had driven. They also wanted the black Malibu, I would tell you. That's what the evidence is here too. He was driving another car on August 20th, a Nissan Altima that he had driven. He was also in another building from where the officers were, so they had to find him. It didn't take long, and they did locate him. And so they get the cars. They also talked to him to get consent to bring the Malibu in. His consent was given, and the Malibu was brought into the sheriff's office to be examined by a crime scene team. So, but what they did then is they then take him to the sheriff's office. All right, so we've already had one story, one version out of the defendant, right? Whenever Steve Kivy encountered him in the alley up in Malcolm just a few days before, he denied any knowledge of Mollie Tibbetts, denied knowing anything about it, other than seeing it on the news and knowing that she was missing. This was obviously a very high-profile matter and a very high-profile investigation, and so he claims to have known about it. All right, so then what do we have? We now have the defendant's, what eventually becomes a confession. Confessions in Iowa need to be corroborated in order to be used as evidence. This confession is corroborated in many ways. So let's look at the defendant's statements to the police. So how did it set up? Powashik County had used Pamela Romero because she was a native Spanish speaker. She was a police officer at the time in Iowa City. She had prior law enforcement experience with the West Liberty Police Department here in Iowa. She was a native of Mexico. She came here when she was a young girl, when she was 10, immigrated here with her family, and moved to West Liberty. She ended up getting an interest in law enforcement, and she started that career with both West Liberty and with Iowa City. And she was an Iowa City police officer at the time that she was utilized in this case. If you recall, she had been utilized about a month before to help with other Spanish speakers, to help interpret. By the way, something that Officer Romero did quite often was to help interpret, not only for her family, but also in her capacity as a law enforcement officer. So she came to Powashik County back in July of 2018 to help with that. And then she came back to then be the person who could talk to the defendant. And doesn't that make sense to have somebody like her? Why not have her? Does she have a ton of experience in law enforcement? No. But she speaks the same language as the defendant. She's a native speaker, right? She can have a conversation with him. The defendant himself told you yesterday he had no problems understanding her, understanding the questions. There was no confusion. It's the same thing that Officer Romero told you. Whenever they were speaking, it was conversational, and they were able to understand each other. But what happens now in a case, though, whenever we have two native Spanish speakers talking on a video? We would love to show you that, to play it, but we can't. I mean, we would need 12 really native Spanish speakers to come in to be able to understand it. So we have to rely on what Pamela Romero tells us the questions and answers were. You saw her on the stand. She's very well put together. She's soft-spoken. She is pleasant. She was the same exact way with the defendant. And she is able to tell you what the conversation she had, what the sorry. Give them a chance to switch. So she will tell you what the conversation is that she had with the defendant while they were at the Poweshiek County Sheriff's Office. What statements were made and what was said during the interview. So initially, what do we get? We get the same story that the defendant had told Officer or Deputy Kivy in Malcolm days before. He didn't know anything about Mollie Tibbetts' disappearance, knew that she was missing, had seen posters and flyers, had seen things of that nature, and had seen that in a store. He even, I think he even said that he had maybe come into contact or had seen Dalton, the boyfriend of Mollie. But what does he eventually end up telling the officers? So they go through the interview, right? So it's deny. Then Officer Romero shows the defendant photos of things that we saw similarly in the videos that show the car. He now knows what? Okay, now my car's in the area. Uh-oh. So how am I going to try to explain that one? All right, so he sees this vehicle in the area. She shows him several photos of it, and then he admits, right? He's now confronted with some evidence that puts him in the area. Now his story changes, right? It changes to, okay, yeah, I saw her, and she was jogging. And, you know, he even makes a comment about her attractiveness. I think there's some dispute as whether or not she said hot or not, hot, pretty, whatever it is, right? He is talking to Pamela Romero, Officer Romero, about the way that Mollie Tibbetts appears. All right, story two. Okay, first one was to deny. Second one now, when shown evidence that his car is in the area, he now moves to, okay, I saw her. Yeah, I did. That's my car. She's in the area. And he tells the officer. There's several points here. As we move through the interview with him, it starts out again with denial. The second one is, I saw her in the area. Then it moves to what? Whenever we get to the field. He confesses to the murder, is what he does. To the confrontation, to taking her, to being the only one, to taking her to the field, to her being bloody, and putting her in the corn. That's what he does. So he admits to observing her and indicates she's attractive. So then what does he then start to tell Officer Romero? He tells her during this interview with her that he admits that whenever he encountered Mollie out on 385th, out on the county road, that she didn't want anything to do with him. She rebuked him, right? Mollie threatened to call the police, right? He did not want that, right? What does that do to him? Makes him angry, right? He admits that. He admits that he became angry. Whenever he gets out of his car, he jogs along with her, he talks to her about that, or talks to Officer Romero about that. Mollie then says, I'm going to call the police. I'm going to call the cops. This makes him mad. She even slaps him. He admits that she slaps him at one point. So there's a physical confrontation between Mollie Tibbetts and the defendant by his own admission out on 385th. And he becomes angry. A very simple motive in the case, to do someone harm. What does he admit next after this confrontation on the road? He then admits that Mollie is in the trunk of the Malibu, and he also admits that he is alone, and he also admits that Mollie's earbuds are on his lap. Those are earbuds that Dalton Jack purchased for her as a gift, right? He then admits to that, right? He puts her in the trunk. He starts driving down the road. We have corroboration of that also. We'll talk about here in just a second. But that's what he says happened. Right? He's confronted this girl. He became angry. She's in his trunk. He's telling us that. There's no other two guys. There's nobody else. He doesn't put anybody else in the vehicle. He had every chance to do that. He was asked multiple times, tell us more, help us more. These officers who could protect him, right? He didn't do it, right? He didn't tell him. Instead, she's in the trunk. We know he's headed south. He admits that he's alone. He admits the earbuds are there. He admits to going to the cornfield. He admits taking Mollie into the corn, and he admits covering Mollie with corn stalks, and he discarded her, and he left her in the corn after covering her with these corn stalks. He was in one of the most remote parts of Poweshiek County. And even though there is a cutout that goes back into the corn where she was found, she's over 400 feet, almost 500 feet into that cornfield. She is unfindable other than by the defendant. So, this statements that he gave to Pamela Romero, Officer Romero, he was given multiple opportunities to tell more, particularly during the end of that conversation that they were having near the cornfield in the car whenever Pamela Romero runs him through the events and tries to get more information out of him. How are we here? How did we end up here? Tell us more. Does the defendant ever admit to stabbing her? He says that he blacked out. He didn't black out. He just doesn't tell her. But he told her everything about the confrontation, about how he got to the cornfield, about how she was covered. And he tells her on 2 occasions in the car, I brought you here. More or less, what more do you want me to tell you? I brought you here. And he did. He led them directly to Mollie Tibbetts. These cops had been searching for her for weeks. He goes right there. He tells Pamela Romero, I did it, didn't I? He claims not to remember, claims that he blacked out. He didn't black out, right? He tells about the confrontation. He tells about Mollie being bloody in the trunk, about hauling her out to the corn, about covering her. He's telling the officer that he did it. He's confessing. He's telling the officers, in telling them those statements, I killed Mollie Tibbetts. That's what he's saying. That's what the statements all point to. We also have, as far as corroboration of this confession, this is a state's exhibit that we used with FBI agent Kevin Horan, who we brought here from Dayton, Ohio. Agent Horan is a cell phone expert, an analyst with the FBI. He's a special agent. He's a law enforcement officer, but has a particular expertise in working on the CAS team with FBI. So we put agent Kevin Horan on the stand. And what he does, what does this help with? All right. We know that, for instance, Christina Stewart saw Mollie jogging on the road, right? Jogging away from her at right about the same time that the video puts Cristhian Rivera and Mollie in the area. So, but that's a human, right? That's a person that's giving you their views. And, you know, that's what she testified to. There's really no reason to doubt it. But this type of evidence that Agent Horan can offer is electronic evidence, right? Not subject to bias, not subject to impressions. And he helps us establish a timeline with regard to Mollie Tibbetts. He helps us also establish 2 different search areas that also help with the investigation. He knows that Mollie Tibbetts was taken at about 8:30 p.m. shortly before, because she ends up, by his calculation, driving directly south just after that between 60 and 70 miles an hour. So we know that's when she was taken. That is consistent with and in conformity with the evidence that we see in the video with Cristhian Rivera's car being in the area with Mollie Tibbetts. It also supports what the defendant is saying at the sheriff's office whenever he's interviewed, that he took her out on 385th. All of the electronic evidence is matching up to help establish this timeline. It's the same location as the defendant states to Romero out on 385th, right? And also whenever he takes them to the cornfield that is down on 460th in southeast Poweshiek County, it lines up with that as well. Actually, if you look at his search area, that is the box on the bottom of this exhibit, it puts the area where Mollie was found is on the far eastern edge of that. So it all matches up, is all consistent. It's the same location that the defendant took the officers to on August 21st of 2018. It matches. That's electronic evidence. It's not subject to bias. This all fits. This confession of the defendant identifies and proves that the defendant, and only the defendant, murdered Mollie Tibbetts. All right? So component 1 is the video, and all the information we've already talked about. Component 2 is the confession of the defendant, where he says he is solely responsible for Mollie Tibbetts' death. Let's move to some physical evidence here. The DNA that we have in the case. By the way, the DNA defendant doesn't know about, right, at the time that he's first interviewed. This is information that came in later. But DNA proves that Mollie Tibbetts had direct contact while bleeding with the Malibu that is owned and solely operated by the defendant, right? That's what we have. How Mollie was found in the cornfield, the physical evidence that we have there, it lines up with how the defendant said that she would be found and her clothing in the field. We'll talk about that here in just a second. So let's talk about what we have here with regard to the DNA. All right, these are the 2 pictures of, there's others of the car that are in, but these 2 photos that are here that are in the fire in the case as exhibits show that the tag that on the Malibu, same tag that Officer Kivy stopped, as well as the blood spot that here that you see with on the rubber seal that that the swab was taken from, that was identified solely as Mollie Tibbetts' blood. So we have that, and there's another blood spot that's in the trunk. If you were to stand at the trunk and open the door and look inside, it's here to the left. There's a spot of Mollie's blood that's in there. Mollie's blood should be nowhere near this Malibu, right? Unless it ties right to the defendant, which it does. And it's the further identity of his involvement. So the defendant has what? Exclusive control of the Malibu. He never, never, never puts 2 men in the vehicle with Officer Romero. Has plenty of chances to do that, and he doesn't do it. He also has control of this car from July 18th to August 21st, when it is seized, when it is taken into custody by the Iowa DCI. So he has the ability to clean it, dispose of things. We don't know what the trunk actually looked like on July 18th of 2018. We know what it looked like on August 21st of 2018, and it had 2 spots of Mollie's blood in there. Did I already say that Mollie's blood shouldn't be in there anywhere? She has no association with this man. It puts her in the trunk. And he knows this. Now, after it's found, keep that in mind for later. It's irrefutable that she's there on the seal and in the trunk. How Mollie was found also corroborates the confession of the defendant. There's a series of photos here that we put into evidence. Underneath this corn is the body of Mollie Tibbetts. I'm not going to show you after the corn is removed. It's in evidence. I'm not going to show you that again. You know what it shows. But these pictures that are here, all of which are in. You notice what drew everybody's attention is Mollie's colorful jogging shoes. That's how she was found. But she's underneath the corn. Now look at that corn and those corn stalks. They look like they've been there for a little while. They don't appear to have been moved, again, by anyone. They're laying across her body as her body decomposes under them. And this is what they found. There's her hand that you can see on the ground. So how does this help corroborate what the defendant told the officer, told Pamela Romero? Well, remember, he took them out there, right? He showed them where she was. He never walked back into the corn with the officers. But what did he tell them that he did? He told them that he put corn stalks over her. Clearly, that's what happened. And that's what he told them then. Again, not involving 2 other guys, right? Only him. It corroborates his confession. He knows that, right? That's what we have here. This corroborates his confession. And again, third component of the states with regard to physical evidence, location, we'll talk a little bit more about that here in a second, and the condition and of the corn and what was on her body, just as he said. It all corroborates it. It's all starting to fit together. Okay, motive. I want to talk a bit about motive. Motive is not an element in murder. If you look at those 4 elements that we were just talking about, motive is not mentioned in them. But the judge has given you an instruction that talks about motive and utilizing it to judge whether or not you want to believe something and what somebody's testifying to. So you certainly can look at their motive, their candor, and their bias. So you can look at motive in this case. So if not the defendant, let's look at motive for a bit. Who had a motive to kill her? Who had a motive to kill Mollie Tibbetts? Who? Okay, the defendants spent a fair amount of time on Dalton Jack. We'll talk about him later before we're done today. But if not the defendant, who had the motive to kill Mollie Tibbetts? A sweet girl, college girl, woman, 20 years old, no other motive. So how does the defendant have a motive? Well, he tells us what it is. Anger is a pretty good one. Anger is probably one of the oldest motives in the history of human beings for why people get hurt. Somebody gets angry and they take steps and act on that anger. Why is he angry? She has rebuked him. Mollie threatened to call the police. We've already talked about this. We'll talk about it again because this does not fit at all with the other two men theory. So Mollie rebukes him. Mollie is threatening to call the police, and the defendant was angry. He says that. He tells us that. He also says when he gets angry, he blacks out. That's what he claims. That's what he told the police. But what do we know? We know that she rebuked him. He did not like it, and he is angry. And the way he reacts to that anger is to stab this young woman to death and dump her body into a cornfield. Now, whenever we look at motive, it's it's not one of those things where you say, "Oh, okay, now it makes sense." Where you like understand really why somebody would do that and have some like common understanding with them. That's not what I'm talking about. What motive is having some evidence as to why something happened. And this is why it happened. And we know it happened because the defendant told us that's what was in his head. One of the key things in this case is that the defendant led officers to Mollie's body. No one other than the defendant knew where Mollie was located. The officers, the cops in this case, investigators, agents have been searching up and down, have been talking to all sorts of people, trying to figure out, who, right? Who would have done this to her? Who would have had a motive to do it? But the defendant, whenever they talk to him, they say, take us to her, and he does. Turn by turn. Takes him right there, right? He led them to Mollie in the dark from Yerby Farms. Remember when they left the police station, left the sheriff's office, they had to go out to Yerby Farms to orient him, and then he took them there. No mention of two other men. Only Mollie's killer would know her location, only that person. And the defendant's testimony proves how important this is. You know why? He knows this. He knows this is the one kind of thing that people can't get past whenever it comes to his guilt, right? That he led them to the body. Wow, that's pretty powerful. So then what does he do? He comes up with another story. Denial, saw the car, takes them to the body, admits to what we've already talked about, and then number 4, we heard yesterday. Because he's trying to explain this one away. All right, other suspects that's been raised here. Here's some of their names: Dalton Jack, Cheney, Pexa, Tomatich, Ishorn, Culver. All these other names that come up. The cops ran these leads to the ground. They looked, right? They talked to these men. They could find no connection, right? Are they just supposed to ignore everything that Cristhian Rivera told them at the end and keep hammering on these guys and keep coming back to them? Or do you follow the evidence in the case? Right? They followed the evidence in the case. There's no evidence that any of these men on that list, including Dalton, who we'll talk about a little bit more specifically later, had knowledge of the defendant, knew who he was, had any connection to his Chevy Malibu, or had any real reason to harm this young woman. None. Dalton Jack had no knowledge. One of the things that the defendant says in his testimony that one of the person, the shorter one, knew the defendant had a child. There's no evidence that Dalton Jack knew that, or that Ron Pexa knew that, right? That he brings up the child because they threatened him. That's the whole reason he says he didn't talk about these two guys. I mean, come on. I mean, no knowledge, no connection between any of these men and the defendant, none. So remember, back in jury selection, we talked about possibilities, right? I think whenever we did jury selection, we did in 3 different groups. I think I asked each one of you, not each one of you here, but each one of your groups about possibilities. Is it possible? I think the example that I used was, can we go outside of this arena that we're in to pick the jury during COVID? And if there's a $100 bill that's laying out there, is it possible it could be there? Yeah, it's possible. But you don't know, right? I could suggest it. Just because I suggest it doesn't make it true. That's the whole point, right? All these possibilities that are thrown out about Dalton Check and Ron Pexa and all these other guys that the officers looked at. Possibility, possibility, possibility. Well, what's the evidence in the case that they're associated? Really none. The evidence in the case that the officers follow, that we're asking you to follow, is what we actually know. And not just because the officers say it, because we can see it. And we can see the maps, and we can see the testimony, and we can, or hear the testimony, and we can hear and see the physical evidence in the case. Just because someone suggests something doesn't make it so. It doesn't mean that you're not firmly convinced about exactly the opposite if the evidence proves that that's true beyond a reasonable doubt. Don't fall for the possibilities. All right. There are 3 other elements. We do have to prove them. I'm going to wrap this up here in just a moment. But the element number 2 is that Mollie Tibbetts died as a result of being stabbed. So now we've got element 1, identification. Was it Cristhian Bahena Rivera that stabbed Mollie Tibbetts beyond a reasonable doubt? You should be firmly convinced based upon the overwhelming evidence that we have in this case about the defendant. All right? So Mollie Tibbetts, then, number 2, died as a result of being stabbed. There's no real issue here. She was stabbed somewhere, I think Dr. Klein said, and Dr. Garvin, who testified, talked about the wounds to the ribs. They did a very detailed examination of her. This woman was brutally stabbed. There should be no doubt about that. We have to prove it. It's the cause of death element. ID is 1, cause of death is 2, right? So the second one that we have to prove, Mollie Tibbetts died as a result of being stabbed. There's no question here. We saw the defects in her jogging bra that are sharp force injuries. I think there were 7 of them. The sharp force injuries that are on her ribs, same thing. So element number 2, right? Element 1, ID, proven. Element number 2, cause of death, proven. Element number 3, this is one of 2 mental health, or I'm sorry, one of 2 mental states that the defendant has to have in order to commit murder in the first degree. The first one is element number 3, which is the defendant acted with malice aforethought, a fixed purpose or design to do some physical harm here to Mollie Tibbetts, which exists before the act was committed. The same injuries that were inflicted upon her prove malice aforethought. Now that we have identity, we know that it's Cristhian Bahena Rivera that committed these acts, that stabbed Mollie Tibbetts. He would have plunged a knife into her at least 9 times. Sharp force injuries to her neck and to her chest, which killed her. If that's not malice aforethought, I'm not sure what is. And really, the injuries to Mollie Tibbetts and this mental state that was used to cause those injuries that existed before he would have plunged the knife into her really is not in dispute. So malice aforethought has to be proven in order to be murder. So looking at the injuries, looking at the circumstances, the stab wounds, element number 3 is proven. The second, or mental state that we have to prove, is that the defendant acted willfully, deliberately, premeditatedly, with specific intent to kill Mollie Tibbetts. The same evidence that we have here, it's a little bit exceeding that because we can go back to the things that happened on the roadway to help establish what his mental state was at the time, the specific intent to kill. But the stab wounds here, the injuries to Mollie Tibbetts, what he did afterwards, he didn't tell anyone, all of those things, how he left her in the corn, all of those things, the repeated stab wounds that took time and effort to do. There's no other intent here other than specific intent to kill. There's premeditation, there is willfulness, and there's deliberation. He tracked her down, he found her on the road, he got angry, and he stabbed her to death, and he dumped her body. That's what the evidence is.
Shout out to the person that just gave us a super chat. This community is just the best. Love you all the different ways.
In this case. So, going back to our first element, we've spent most of the time this morning talking about that. On or about the 18th day of July 2018, it was the defendant who stabbed Mollie Tibbetts. Mollie Tibbetts died as a result of being stabbed. The defendant acted with malice aforethought, and the defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill. This is a saying that I learned from a DCI agent that I worked with. His name was Bill Baszler. He's up in Mason City. He had this on his wall. And Bill's been retired for quite some time. I worked a number of cases with him. And he had this on his wall. It always has struck me as very much driving to somebody's common sense. And that's what we want you to do. We want you to look at this through the lens of your common sense. That's the instructions allow you to do that. And that's what we want you to do, is to look at that through common sense. What is this? When you hear thundering hooves, take horses, not zebras. What does that mean? It means look at the obvious, right? That's what it's after. Don't look for the exotic, right? Look for what the evidence, where it takes you. Look at what the proof is in the case. Look at those things. What the defendant said he did. He never introduces two men till yesterday. Think about that. What is the obvious in this case? Cristhian Bahena Rivera is guilty. He's guilty beyond a reasonable doubt. Looking at all of this evidence in the case, I do get a chance to, by the way, talk to you after Mr. Freeze is done, and we'll have an additional time to do that, and we'll cover some more ground, particularly as it relates to some of the statements the defendant made yesterday. So we'll talk about that. But looking at the evidence in this case, all of it, the video, the confession, the blood that's in the trunk, all the other circumstances, all the other investigation that went into this, it all points to one person and one person only. The judge gave you an instruction right towards the end of the set of instructions that he read. Here's what he said. He told you that your job as jurors, your sole duty as jurors, is to find the truth and to do justice. That's your job as jurors. And looking at all the evidence in this case, looking at everything that we have, all of the circumstances, the truth here is overwhelming that the defendant murdered Mollie Tibbetts on July 18th of 2018, that the defendant committed murder in the first degree. He took Mollie's life. He stabbed her to death and he dumped her in a cornfield. That's what happened. Justice in this case, ladies and gentlemen, is a verdict of murder in the first degree. Thank you.
We're back on the record. We're in the presence of the jury. Mr. Bahena and the attorneys of record are all present. Mr. Freeze, at this time, you may give your closing on behalf of Mr. Bahena.
Thank you, Your Honor. May it please the court.
Counsel.
Mr. Brown, Mr. Flavor. Morning. Everyone hear me okay? Good? Okay. If you can't, give me a wave, do something, get my attention. We have the construction again, and I have the microphone kind of near me, so if I need to raise my voice, I will. I won't be yelling at you. I'll just be trying to project and trying to get your attention. All right, where to begin? Let me start by, I guess, saying that I would be remiss if I didn't just take a moment to say thank you, okay? Thank you for your time. Time is your most precious and valuable resource. It's all we have, okay? So one thing you can spend, but you can never buy, you never get any more of it. It's the most valuable thing you can give somebody, is giving them your time, being on time. Your time and attention is something that we don't take lightly. We have 6 kids, so we value time, being on time, and attention. And, you know, we've been watching. You watch us, we watch you. And you've been very attentive. You've welcomed us into your community. Davenport has been very kind to us. You folks have been very attentive. And you've listened very closely, watched very attentively to some evidence that's been difficult, testimony that's been conflictual, and you've sorted through it, I think, or you will be sorting through it some more. So that's not taken lightly by us. by us, we're very thankful. On behalf of my wife, Jennifer, and most importantly, Mr. Cristhian Bahena, it's very much appreciated. Okay, and that's just not me tossing platitudes at you because we're supposed to, or us just being polite. Okay, that's genuine. We appreciate the fact that you've taken basically 2 weeks of your life, sat through a day and a half of laborious jury selection in that big building, and let us ask questions and pry into your life, and taking the time to listen to the evidence here. We truly appreciate that. Thank you. Okay, the other thing I want to make very clear is that Mollie Tibbetts is truly an innocent victim. She was absolutely an innocent victim here. No doubt about it. This young woman was a spectacular young woman. She was destined to do great things. She was destined to become the change that she wanted to see in the world. She was just about to spread her wings and fly. We acknowledge that. We sympathize with her family. We offer empathy to them. This young lady was on her way to being someone special. No doubt about it. Absolutely no doubt about it. The loss of Mollie Tibbetts is tragic. Absolutely tragic. And the reason I mention that is because the loss of someone like that can evoke a lot of emotion. And it has evoked emotion. And that can be a problem when you are sitting as a juror. Because when you're sitting as a juror, emotions have no place in that deliberation room. You don't decide this case based upon emotions. You don't decide this case with emotions tugging at your heartstrings. It's not your job to right or wrong. It's not your job to impart vengeance. It's not your job to bring justice for Mollie. She deserves justice, absolutely, but that's not your job. Your job is to do justice, period, full stop. Your job is to provide a logical, analytical, almost surgical and mechanical application of what you heard here and the instructions, and that's it. The analysis is simple. The analysis is not whether you go back in that room and decide, I think he did it. The analysis is much, much different than that. The analysis is whether this table and the people from this table, the government of this state of Iowa, and the people hired by the government of this state of Iowa, and the resources they've produced have brought forth enough evidence to prove this case and each and every element of the charge beyond a reasonable doubt. That is a huge standard, folks. That is a high standard. And you cannot forget that, and you must keep that in the forefront of your mind. It must be right here all the time. You can't be swayed by emotion. You can't let pictures and emotions of those pictures get to you. You must be logical, and you must do your job. Judge Yates has told you that. I'm reminding you of that. I'm not talking at you about it. I'm just cautioning you, because that's what justice is. Justice is, have they done their job and proven Cristhian Bahena guilty beyond a reasonable doubt? Have they proven that man, that young man there, is he a murderer? have all the elements of murder in the first degree of that young man in the middle been proven. Like I said, Mollie Tibbetts deserves justice, but so does Cristhian Bahena. He deserves justice. And your job is to find the truth, judge the facts, and do justice. Now let's set the stage. It's important that you know all the facts, okay? It's important that you understand where we were in July 2018. A lot of time has passed since July 2018. We've lived through a pandemic. Some of us have lived through tornadoes, derechos. Just a lot of time has passed. But this case is much, much different than any case I would submit that you have ever heard, okay? Within a couple days of Mollie's disappearance, the Iowa Division of Criminal Investigation is on scene, okay? Agent Trent Villada is there, and the investigation begins. Shortly thereafter, the Federal Bureau of Investigation is on scene. A number of local law enforcement agencies are on scene. In Brooklyn, Iowa, a town of 1,400 people, Homeland Security shows up in Brooklyn, Iowa, for a missing 20-year-old girl. Use your common sense. Use your experience. When is the last time something like that has happened? It was a circus in Brooklyn, Iowa. Media was everywhere. You heard Agent Villada talk about the media that was there. You heard him talk about this reward that was just skyrocketing. That doesn't happen here in Iowa. Your experience tells you that. Your common sense tells you that. For a missing 20-year-old jogger, we didn't even know that she was dead yet. We didn't know she was picked up off Interstate 80 and abducted. We didn't know anything about that. But like Agent Villada said, within 5 to 7 days, he had the, quote, unlimited resources of the federal government with the FBI. Think about that. Think about that. That is unprecedented. Unprecedented. Now, why do I tell you that? I tell you that because I want to hearken back to Mr. Claver's opening statement. In his opening statement, he said that the DCI comes in town and they kick off an extensive investigation. He tells you the DCI is in town, the FBI is in town, Homeland Security is in town. And every lead came up empty after what he called exhaustive and intensive investigations. 4 weeks, you heard they were canvassing, they were searching everywhere. You saw the map with all the red dots, and they had nothing, okay? Imagine the pressure to close this case. Imagine the pressure to put this case to bed, because that's the context in which this arrest and this charge happened. Every lead, Mr. Claver said in his opening, came up empty. Absolutely right. Some of the investigation was sloppy, but it really got sloppy when Cristhian Bahena Rivera got targeted. Because folks, what happened here was they closed a case. They didn't solve a case. To coin a phrase from Agent Villada, in his mind, Cristhian Bahena cleared Rod and Pexa. I would expand on that. In his mind, Cristhian Bahena closed the case. Good enough for them. Let's close the case, shut the book, get everybody out of here, and we're done. But they didn't solve the case. They didn't get enough evidence to prove this case beyond a reasonable doubt. Mr. Claver, in his opening statement, also told you that they found the video of the Malibu. That was good police work. That was good police work. We're not going to suggest to you that Cristhian Bahena Rivera's Malibu was on that video. That was him. He testified to that. You saw him on the stand. Or that was him driving that car. We'll give you that. Absolutely was him. He said that Miss Tibbetts' blood was in Cristhian's Malibu in the trunk. That's true too. We aren't going to dispute that at all. He didn't mention to you that there was a mixture of blood in the trunk. And they talked about Cristhian's quote unquote admissions, or what Mr. Brown called a confession, which we wholeheartedly disagree with. What is missing in this case? That's really what you got to look at. What is missing? Because there's a lot missing in this case. We don't have a murder weapon. No murder weapon ever was discovered in this case. And it wasn't for lack of looking, at least as it pertains to Cristhian Bahena Rivera. Okay? They found a folding knife at his trailer. They sent it into the DCI lab, tested it. No blood. No blood. They found another knife, black knife. Sent that in. No blood. Nothing. However, think way back to when Tara Scott talked about her initial crime scene analysis. Remember, she went to 622 West Des Moines Street. A couple days after Mollie went missing, they sent the DCI crime scene team up and they looked at the home at 622 West Des Moines Street. And they looked at it very, very closely. And what did she note? She noted in the hallway there was a gun safe with a number of guns in it. But of particular note was a loaded pistol in a little cabinet hanging on the wall with several knives, hunting style knives. Some of them were folding knives. Bet you if they'd went and looked, they may have found one with a camouflage handle. But they didn't bother to look. Why? Because they'd already made up their mind. We'll get to more of that later. What else don't they have? They don't have a primary crime scene. They don't have a primary crime scene. Where was Mollie Tibbetts killed? Was she killed on 385th Street? Did someone stab her 9 to 12 times along the blacktop where she was jogging? Did someone stab her in the throat or do the slashing motion of the throat and stab her several times in the rib and then penetrate her skull on 385th Street, where you heard about where all these houses are and the cars that were traveling out there, and they talked to darn near, I would submit, everyone on 385th Street, and they didn't find one piece of evidence, not any blood. They had it narrowed down. We saw the map of the cell phone technology. They had a pretty small window as to where they'd find something. They send any type of canines out there to find blood. Oh, well, the weather was bad. I forgot. It was humid. It was hot. It had rained. I mean, they have an excuse for every piece of evidence they don't have. But they don't have a primary crime scene. Or was she killed on the 460th Avenue address? Did someone take her 430 feet back in this location and kill her there? We don't know. What investigation did they do to find a primary crime scene next to the cornfield? Or was she killed right there in the cornfield? I highly doubt that. I highly doubt someone killed her right in the rows of corn, and there wasn't some other evidence there to establish that. We don't have a primary crime scene. Well, they'll pass it off and explain it away by, well, it's been 5 weeks. The weather was bad. The corn was tall. You know, they'll find an excuse for everything. That's not Mr. Bahena's problem. Okay? That's their problem. They have to prove it, not him. Okay? They had the unlimited resources of the federal government. They had drones up in the air. They brought a guy in from Dayton, Ohio, for the sole purpose of analyzing the data from one cell phone. And that's the evidence they put on here. They had unlimited resources. Unlimited resources. Mr. Claver told you in the opening statement, his sheriff was up flying around in a helicopter. And they can't even tell you where she was killed. No evidence come off that stand as to where she was killed. None. No forensic evidence at all. They don't have an eyewitness. They have no witnesses. Zero. None. They talk about a confession. We're going to get to that in a little bit. But we dispute greatly that what they attribute to Cristhian Bahena as a statement can be characterized as a confession. Absolutely cannot be. Absolutely cannot be. Motive. Now, motive, Mr. Brown talked about. But you really have to use your common sense here, folks. You really got to think about this one. This man right here, 5'7" 125-pound illegal immigrant, undocumented immigrant, gets angry at Mollie Tibbetts, who he had never met before, who he was trying to get to know, if you believe that story, and resorts to killing her, stabbing her 9 times, or maybe 12, 3 more times, because he's angry. The only evidence they have of his anger is this story he gave Pamela Romero. The evidence we do have about Cristhian Bahena is that he's not an angry man, that he's not violent, that he's a family man, he's hardworking. He came to this country for a reason. And you can bet he wanted to stay in this country. And the concept that he got angry and killed a woman who he had just met defies any logic. Folks, we've all been rejected in our lives. We've all perhaps have walked up to someone, had the courage to ask them on a date, or had the courage to try to get to know someone and been told no. May have been told no in an epic way, been embarrassed by that person. Common sense tells you that you aren't going to just stab that person, let alone a person like Mollie Tibbetts. It makes no sense. They have no motive as to why this man would commit that act. And then they have no scientific evidence that connects him to the killing. They want to talk about the trunk. They want to talk about the cornfield, both of which we admit. But having her in the trunk and putting her in the cornfield does not mean he killed her. Think about that. The burden of proof is on the state to prove all that. And that, folks, when you look at what's missing, is a reasonable doubt? What is a reasonable doubt? Reasonable doubt, long and short of it is, the judge will tell you that if after a fair and full consideration of all the evidence or lack of evidence, okay, if they don't produce the evidence, that's just like evidence you can consider. Lack of evidence produced by the state. Mr. Bahena doesn't have to produce anything. He doesn't have to tell the state anything when he has the opportunity. He doesn't have to, when he's questioned, tell the state about these two masked men. It's not his obligation. It's their obligation to prove it. Don't let him shift anything. Don't let him oversimplify and make it sound like he has to do anything. Their burden. You have to be firmly convinced of his guilt as to each and every element. All four, in order to convict him. If not, you must find him not guilty. Now, what does firmly convinced mean? Good question. You're not going to find anywhere in those instructions where it's defined what firmly convinced means. You have to determine for yourself what that means. I would suggest to you that in your deliberations, to be firmly convinced, you're going to need to know that Cristhian Bahena did this. You can't just think he did this. You must know that based upon the evidence that they have produced, that he killed Mollie Tibbetts, that he committed this crime, and the state has proven these elements. You best know. You best not think. That's the difference between whether or not you're firmly convinced. Instruction 14 defines murder in the first degree. Element number 2 is that Mollie Tibbetts died as a result of being stabbed. We admit that. There's no doubt about that. Somebody stabbed her, and as a result of those stab wounds, she's dead. No problem. But the state has monumental issues with 1, 3, and 4. Monumental issues. We'll go through those. Element 1. What evidence has the state produced to prove element 1? They have a drop of blood on the trunk seal. And look at that photo. The drop of blood is a centimeter. I mean, it's small, okay? They have her DNA in the trunk and her body in the cornfield that Cristhian took him to, okay? All facts that we don't dispute. He testified to that. But what must you believe to establish element number 1? You must believe the testimony of Pamela Romero. Okay? Now, Mr. Bahena told them enough to get them to the body. Okay? This was an 11-hour interrogation. 11 hours. Okay? After he had worked a full day at the dairy. Okay, now he works at the dairy. That's hard work. And if you think it's a coincidence that they waited till the end of the workday to get this guy and bring him back and question him, you got another thing coming. So he'd worked since 4:30 in the morning. They get him. He voluntarily agrees to go speak. He's compliant. He's a yes man. He talks to Pamela Romero and other officers for 11 hours after working in a dairy where he works, mind you, 12 hours a day plus 12 out of every 14 days. He tells them enough to take him to the body. Why did he do that? Very simple. He was protecting his own. He was protecting his daughter, Iris. He was protecting the mother of Iris, or protecting his daughter, Paulina, and the mother, Iris. I'm sorry, I misspoke. Now, this 11-hour interrogation was recorded. And you can see from the photographs, those are snapshots from the interview, that there were times where English speakers were in there. Okay? Agent Valletta speaks English. You heard Kristen testify the guy standing up was yelling at him in English. Agent Valletta was calling him a liar at the point he's sitting here. Yet, you didn't get the benefit of seeing any of the interview and judging for yourself the credibility of Cristhian Bahena's statement or the authenticity of that interview. Think about that. This case had the unlimited resources of the federal government there. FBI, right there. DCI, right there. These guys are the best of the best that we have. These guys know how to interview. They've handled homicide case after homicide case after homicide case. They've interviewed people over and over and over again. And they send in Pamela Romero, a cop who had a total of about 2.5 years experience, whose law enforcement training was only the academy, and 16 hours of interrogation and interviewing training. Folks, you spent 12 in jury selection. Cristhian Bahena spent 12 hours working that day. They sent the most inexperienced officer they could into a marathon interrogation with a suspect in a homicide case that had more attention than they've ever known, because she was a quote unquote native speaker. Now, why on earth would they not send in one of those agents who really knew how to interview and interrogate and let Miss Romero do the translation? She was fluent, which, by the way, her saying she's fluent in Spanish is like one of us saying we're from Iowa, therefore we're fluent in English. There's a lot of people who speak English that aren't fluent, folks. That's just the way it is. Just because you grow up here doesn't mean you're fluent. We can speak the language, but I would submit you wouldn't be the best at translating. You wouldn't be the best at interpreting. Agent Valletta wanted to sit behind the curtain and control the interview. But the problem is, when they come here to the courtroom and want to produce evidence, they can't, because now it's all in Spanish. So now the state can sit at the table and sit behind the curtain and produce the evidence by having Ms. Romero testify. And you folks can't judge the evidence. If that evidence in that interview had been with someone who was an English speaker, that evidence would have been played. No doubt about it. No doubt about it. But since it's in Spanish, we only get to hear bits and pieces from what Ms. Romero said. And you're told to rely upon that as a confession. Folks, that's a problem. That's sloppy. And note, when the supposed confession came. Remember, he was in that room for several hours. I think they took him in 3, 4 o'clock, maybe 5. It doesn't really matter. But what were they insistent on saying? What were they insistent on saying? We're not from immigration. We're not from immigration. We're not from immigration, right? Because they know that that's the one thing that a Mexican national, an undocumented worker, fears most. And they wanted to put him at ease, and hopefully he would open up. And he didn't. He kept denying, because he knew that there were problems if he came forward. Iris was in danger. Paulina was in danger. So what did they do? At 11:30 p.m., they called immigration. When he didn't give them what they wanted, they called immigration. And they put that detainer on him so he couldn't go anywhere. They didn't get what they wanted, so they put the hold on him. So they weren't there for immigration until they didn't get what they wanted. Until he didn't tell them what they wanted. That's 11:30 at night. So now he can't go anywhere. And yet they continue. They continue at him. And you saw pictures. He falls asleep. They wear him down. They wear him down. You heard Christian say that they said things to him. Pamela Romero said things to him. Help yourself. Help yourself. She was the good cop. She was the nice lady. Help yourself, Christian. Help yourself, Christian. Maybe there was something wrong with you, suggesting the blackout. This all makes perfect sense. He wanted them out of their hair. And when finally she says, Christian, think about the family. Think about if you were the parent of that little girl. That's when he relents and tells them just enough to take him to the body and gives them this blackout story, gives him the story about being angry that's been spoon-fed to him. Now, the bad cops are in the room, too. The classic good cop, bad cop. I mean, this is straight off TV. Agent Valletta, right in his face. What is he, 1.5 feet? You're a liar. You're a liar. You're a liar. The tall, skinny guy in the back is yelling at him, using words that Christian can't understand. You can assume what those words are. I'm sure they're curse words. But again, they had the full resources of the federal government, and they couldn't give you any basis to know what's been said there because it was in Spanish. You have to believe Pamela Romero. And you saw her up here. Her answers were evasive. She was non-responsive in many of her answers. She was obviously biased in her answers. She couldn't just say yes or no to an answer. She had to try to explain herself and take it in a different direction. She wants to get back into law enforcement, even though she's out of law enforcement. She had never done a homicide interview in her career, ever. What a colossal blunder. What a colossal blunder. They had the ability to videotape it. They had the ability to let you hear it if they chose to use someone who spoke English and translated it, and they didn't do it. They didn't do it. Element 3 and element 4 you'll find in instructions 17 and 18. And those are malice, forethought, and malice, and premeditation. Now, I'm going to just kind of veer off just for a second. But let's assume for a minute that you do buy into what Mr. Brown's selling. If you take Mr. Bahena's story, the first one he told police, that version of the events, that he got angry and just started stabbing Ms. Tibbetts, there's absolutely no evidence of premeditation. Did he think or ponder upon a matter before acting? Absolutely not. Absolutely not. Not a speck of evidence of premeditation, which is required for murder in the first degree. Did he deliberate? Did he weigh in one's mind? Did he consider? Did he contemplate or reflect? Absolutely not. That's even if you buy the state's theory. Malice aforethought, a fixed purpose or design to do some physical harm to another, which exists before the act is committed. Again, even if you buy what they're selling, they can't prove malice and they can't prove premeditation. That would take you to murder second degree and maybe voluntary manslaughter. You folks are smart, you folks are bright. I'm not going to take you through those. Instruction number 6 is you are to decide the facts from the evidence. And again, this goes back to jury selection. And Mr. Brown asked many of you if you would hold it against him if you didn't have video evidence, if you didn't have video of the crime. And of course, there's not video of the crime. Very few places in the country have video surveillance all over the place. But you should hold against him and hold against the state those times where they had the ability to video things, record things, and not produce it. Absolutely should. Because that's the true way for you to judge the facts. Mr. Brown talked earlier about the unbiased digital evidence of Kevin Horan. What about the ability to have video evidence that is unbiased and able for you to analyze yourself? And again, I have to come back to Agent Villada and his statement. We had the unlimited resources of the federal government, the FBI, who investigate major federal crimes, Homeland Security, they investigate terrorists. They had drones up in the air. They had guys from Dayton, Ohio doing these fancy calculations on cell phone towers. Which, by the way, they did one cell phone tower. They provided you evidence of one cell phone tower, Mollie Tibbetts. What about his cell phone tower? Most importantly, what about Dalton Jack? Victimology. Victimology. Remember that statement? Let's get to know people who were closest to Mollie Tibbetts. Let's learn her patterns, her habits, what we're doing, what she does, who she associates with. Victimology. Where are Dalton Jack's phone records? If he was in Dubuque, he had a cell phone. Where are the tower records? No, let's bring in his boss, who's going to come in and testify for him. Where's the unbiased, non-biased records? You saw some records with Dalton Jack because I was trying to cross-examine them with him. And you saw how that went. You saw the fight with those. We tried to talk about his text messages between him and Jordan Lamb, between him and Mollie Tibbetts. We talked about his affairs. Why on earth would you not just put up Dalton Jack's phone records if he truly was in Dubuque, if he truly worked until 7 p.m.? Why not? unbiased digital evidence that we couldn't refute if it truly was there. Unlimited resources of the federal government. You don't think this Kevin Horan couldn't have done that? Why didn't they not produce that for you? You can infer from their lack of producing that evidence that it was damaging to them, and you should. Why not? You heard the testimony of that man, and we'll get to it a little bit, but they could have, and they chose not to. They could have, and they chose not to. Okay? These things are everywhere. These things are the television of the 21st century. Your cell phone, your smartphone, it's unbelievable. You all know it. You sit around your house and you talk about recipes. You talk about buying a new boat. You talk about buying a gift for someone, and next thing you know, you're on your smartphone looking up the internet, and there's something pops up that you talked about. It's scary. You can order something off Amazon. You can go to Hy-Vee.com. You can go to Walmart.com, and you can know that the item you purchased is off the shelf or the item's been shipped, and you can track it in real time. You can know where it is anywhere in this country like that. Okay? But the state cannot produce for you a video of Cristhian Bahena from the sheriff's office to Mollie Tibbetts' body. You would think that this man says, I'll take you there. I'll take you there, right? That good policing, that all these years of experience, the best that the state of Iowa has with special agents, the Federal Bureau of Investigation, the Division of Homeland Security are here. They're all carrying these at least. And he gets out of the car, supposedly. I'm sure it's a patrol car that has at least a recording camera on it for when someone gets pulled over or something. That they don't at least take a moment to record him going to the edge of the corn and pointing out the body so you can view for yourself what he's doing. They don't have that. Why not? Let me tell you why not. Because they had nothing for 4 weeks and they were excited and they cut corners and they rushed to judgment. That's exactly why. They wanted to close this case, and they wanted to close this case now. Just like when out at the scene, they had Cristhian in a car. And again, if you want to believe his confession, which is now at, 6 o'clock the next morning after he was taken from his workplace. And he said, supposedly, according to Pamela Romero, I brought you here, didn't I? Question mark. That must mean I did it. Question mark. Mr. Brown can fight me on the punctuation. Can fight me on whether or not it was one of those things where he's throwing his hands up saying, I brought you here, didn't I? Or whether he said, I brought you here, didn't I? You know, sarcasm, vocal inflection, context, all that stuff matters when you are talking to someone. You can't just say that, well, Pamela Romero said, he said, I brought you here, didn't I? After 24 hours of being awake. They didn't have a recording to show you, after they have the body now, okay, they have the body. They have Mollie's body. At that point, at least, you'd think they'd time out. Let's get somebody on this case now who really knows what they're doing and do a proper interview. And let's translate it. Let's get the case agent, Valletta, on this and do a proper interview, because we want to wrap this up tight. But yet they didn't do it. They wanted to just close the book. The state seems to want you to just take their word for it. Take Pamela Romero's word for it. Therefore, he's guilty. You've got to believe everything she said. You got to believe that statement he made was absolutely credible without any corroboration whatsoever to what she said. This is a murder case. A murder case of Mollie Tibbetts. Put it in context. What was going on there? Who was all there? Why did they cut the corners that they cut? Remember this instruction. We start talking about what witnesses you can believe. Inconsistent statements, their appearance, their conduct, what interest they have in the trial, what's their memory. That tells you who you can believe and who you can't believe. You saw Cristhian Bahena's testimony. He sat there yesterday and he gave you his version of the events. Mr. Brown suggests that those versions of the events were as a result of knowing what the evidence was and having time to rehearse them. And he says it makes no sense. It makes every bit as much sense as the state's theory that an undocumented immigrant runs up alongside Mollie Tibbetts on a highway in broad daylight, gets angry, and decides to stab her. Absolutely does. Let's talk about the video evidence. And here there's a mistake here. The jogger was not seen at 8:07. She was seen at 7:45. Okay. So 7:45, she's running north. I think it's on Boundary Street in the intersection of West or East Des Moines Street. The Malibu went by heading east out of town, or east by Logan Collins' house at 8:07 p.m. Agent Reeson said it was 3 minutes off on his cell phone, so it's about 8:10 p.m. Horan's testimony is that Miss Tibbetts would have been traveling south and east at 8:20 p.m. So
I'm going to object. That's not the evidence.
Well, Mr. Freeze has pointed out that there is something inaccurate on there.
Well, can we approach? I'm sorry.
Yeah. Go ahead and continue, Mr.
Very well.
Freeze.
the video evidence, you have to put together a time frame, and you have to ask yourself if this crime could have been committed by 5'7" 125-pound Cristhian Bahena in that short time frame. Could he have overpowered this woman? Could he have stabbed her 9 times, tossed her in the trunk, and then headed south? That makes no sense. Let's look at the facts and apply your common sense. Cristhian Bahena works 12 hours a day, 12 out of every 14 days. He averages 75 hours a week. 75 hours a week. The other 2 days out of every 2 weeks, he sees his kid. He has a date the next day. You heard his aunt talk about that. You really want to believe that Cristhian Bahena, the man you saw on the stand yesterday, the undocumented immigrant who has spent years working in this country, working hard to remain undetected, going to town only when necessary, working under an Anglo name, John Budd, having no history of law enforcement contact, no history of violence, is brazen enough to pick up a woman, abduct her, and maybe kill her in a span of 10 to 20 minutes. Folks, this was planned. Not by him, by someone else. Let's talk about the DNA evidence. DNA evidence is not helpful to the state. Absolutely not. Now understand the DNA evidence is, we expect Mr. Bahena's DNA to be in his trunk, right? We would expect that, especially if he was involved with killing Mollie Tibbetts. Have they presented you any of Mr. Bahena's DNA from that trunk? No. Not one speck. We expect Ms. Tibbetts' DNA to be on her person. Only Ms. Tibbetts and Cristhian's DNA was submitted to the lab. Now, what the problem is with the DNA is exactly what the reports tell us, and then as explained by Dr. Spence. And that is, first of all, remember the testimony was that the investigators and the lab didn't test the trunk liners until a year later at Mr. Brown's request. So investigators didn't deem it even relevant to try to find someone else's blood, Mollie's blood, inside the trunk. They had it on the trunk liner, on the gasket, that little piece of blood you saw, but not to see if she was actually, her DNA was in the trunk. We're glad that Mr. Brown asked for that because it gave us some very compelling findings. Okay. Now, the DNA that was found on the trunk liner, okay, there's item 59-3. And that's a really small, less than a dime-sized cutting that Tara Scott took, okay, small. It had 10 accounted for alleles, those little identifying markers that Dr. Spence talked about, that were not from Cristhian Bahena or Ms. Tibbetts. They came from an unknown male beyond the major presence of Ms. Tibbetts. So an unknown male was there. And we know that from the Ms. Scott herself, it was a mixture of 3 people. 3 people. And what's important is Ms. Tibbetts' DNA is on that very small spot mixed in with 3 people. Okay. Right there in that very small spot. Item 60.1, there were 14 unaccounted for alleles, not Ms. Tibbetts and not Cristhian. 61.1, 5 unaccounted for alleles. Can't tell if it's male or female. Basically what it tells us is there's other people's DNA in that trunk mixed with Mollie Tibbetts in those very small portions. Not somewhere else in the trunk, but right where Mollie Tibbetts' body was, in the exact spot. Why is that important? Because we have no other DNA to exclude anyone, folks. Again, victimology. Why on earth would you not take Dalton Jack's DNA? Remember that? Crime scene team come into 622 West Des Moines Street. They take a Dr. Pepper can. They take an Arizona tea can, and they swab everybody in Mollie's family for DNA. Of course, Mollie's DNA is going to be on that can. Why were they even in that bedroom? They were thinking that maybe she was in that bedroom with someone else. They wanted to get her DNA. Of course, her DNA was going to be on that can. Why would they need to know that? Was she going to abduct herself They were in that room to see if someone else was in that room, yet they did nothing to get DNA to exclude people. That's the funny thing about DNA. It doesn't need to point the finger at anyone, but it can exclude people. Would that DNA have excluded Dalton Jack? Maybe, but we don't know because we cut that corner. We just wrote him off right away. July 25th, the testimony was that he was cleared. But then on July 27th, they interviewed him again, and he admitted that he lied. He had withheld information. And he told you here on the stand, he didn't deem that him having an affair on Mollie was pertinent. He didn't think it was relevant to the case. Well, the agent sure did. That's why he was called back to talk about it. But they didn't test anybody's DNA other than Cristhian and the Tibbetts family and all the Hispanics at Yarrowby Farms. They did a canvass of the entire town and didn't test anyone else's DNA. No one else's. Why would you not do that? So you can at least exclude people. You had the resources of the federal government there, folks. DNA is an exclusion tool. It acts like a funnel. It helps us figure out who couldn't do it as well. Also recall that there were no fingerprints in that trunk. Cristhian Bahena's fingerprints were excluded from being in that trunk. Someone else's fingerprints were in that trunk. And in fact, the fingerprint cards that they were sent in were done so sloppily that they couldn't compare the other fingerprints against it. And they didn't ask to do any more. Remember, Tara Scott's report, Anna Young's report were uploaded and made available to Agent Villada. He had them right there at his disposal. He could have done more investigation anytime he wanted. He didn't. He didn't. They didn't get you any more digital evidence. They didn't get you any video. They didn't get you any DNA, any more fingerprints. They just say, believe us. I mean, and the testimony yesterday, you know, the DCI agent's on there after the FBI says, hey, go get some of this blood from 2384 460th Avenue, a mile from where Mollie is found. And they get it, and they don't test that either. Even though the FBI says do it, Agent Villada doesn't do that. And that was days and days and weeks before Mollie was found. You know, don't do that either. That brings us to Dalton Jack. Ask yourself this question. Why did the state even call Dalton Jack as a witness? Think about that. What do you have to add? He wasn't in town during the abduction. He didn't know who committed any of the elements. He wasn't here. That's what they're saying. He was in Dubuque. He had nothing to add. He wasn't a witness. Where was he? Why? What did he know, really? They knew he was a problem. They knew from the jump that this guy was a problem. That's why they investigated him and questioned him after they cleared him. That's why they called his boss today, because they heard his testimony. Remember that jury instruction. Whether a witness has made inconsistent statements. Remember, Mr. Jack didn't even want to be here. Didn't want to be here for the love of his life, to make sure she had justice. What kind of person is that? Well, it's the same kind of person that would have an affair on the love of his life while he was planning on getting engaged to her. It's the same kind of person that would portray their relationship as rosy to the public while it's rocky in private. It's the same kind of person who was losing control of Mollie. She was going to fly. She was outgrowing this man. He was angry. He has a history of being a fighter. And they knew he was a problem. All Dalton Jack had to add was his testimony that he did not do this. And his alibi that the state gave you was his inconsistent statements. No video cameras from the hotel. Not a single receipt that shows that he was at Walmart or got gas or went to the gas station. They got any beer. Nothing. No time cards. Cell phone towers, you talked about those. We know where Miss Tibbetts was, but we don't know where Dalton was. Easily found. Ulysses Felix, you heard that name come up a number of times. Ulysses Felix knew both Mr. Bahena and he knew Dalton Jack. Iris Gamboa's cousin. He knew Miss Tibbetts. He knew the defendant and been to his house overnight. That's the connection. Ulysses Felix is the same one who moved in with the Tibbetts family after his parents took off. That's how people knew where to find this guy. We don't dispute Kevin Horn's testimony. Not at all. We just want to know why it wasn't done for Dalton Jack. This, we think, is a big point. Dalton Jack texts Miss Tibbetts at 8:18 p.m. says, my data straight up won't work. We think at 8:28 p.m., within 10 minutes, Miss Tibbetts is in the trunk and driving at a high speed away from Brooklyn. Within 10 minutes of her being abducted, with her being killed, he mysteriously sends a text that says, my data straight up won't work. It won't work. And 10 minutes later, she's in a trunk going at a high rate of speed away from Brooklyn, Iowa. Where was that text sent from? Where's the tower information on that? That's a suspicious text if I've ever seen one, folks. It sounds like someone trying to cover his tracks. But believe his boss. Don't believe unbiased evidence. Remember his testimony that Jack still can't figure out what he was doing that night. We asked him, do you recall telling the agents that you showered that night and watched Rush Hour 1 in your room? He said,
I'm sorry, Chad. I'm going to object. This transcript is not in evidence.
Sustained, Mr. Freese.
well, we asked him, did you have anger problems? He answered, I did in high school. You like to fight? He said, yes. We asked him, do you recall telling agents that on July 18th, you were in your room showering and watching Rush Hour 1? He said, is that the night of the 18th? He said, question, yes. He said, yes, I do. But then he come to court and said, your testimony today is you were outside drinking beers with the boys. Answer, yes. Question, I asked him, so you told the officers on the 27th of July a different story, right? I suppose so. This guy gave different story after different story. I asked him, who's that woman you had an affair with? Her name was Jordan Lamb. What'd you tell the officers the reason you withheld that information? I didn't deem it necessary. I didn't think it was pertinent to the case. I went on to ask him, you didn't want Mollie moving in with friends. You wanted her moving in with you. Answer, I was upset that she went back on the plan that I had been going with for the last year and a half after that. You were angry, I asked. He said, correct. And then finally, when I asked him about his temper, I said, it was short-fused, wasn't it, Mr. Jack? And he said, yes, liked to fight Yes. Ron Pexa. What do we do with Ron Pexa? Ron Pexa's address is 2410 460th Avenue, less than a half a mile where the body was found. His property is adjacent to the property where Mollie was discovered. Jamie Slife came in and told her truth about who this man was. You needed to hear what she had to say because law enforcement would not. She called in the tip line, called the sheriff directly. No one would listen to her. Now, did Ron Pexa have anything to do with the demise of Mollie Tibbetts? We don't know. But what we do know is that no one investigated him. There were separate tips. Someone called in, called him a maniac. Someone said he had a torture room. That didn't come from Jamie Slife. But what Trent Villa to do with that? You know, we would walk around and we talked to him a little bit. Didn't document it in a report. Didn't document it in video or audio recording. It's because he was taking care of his own. Ron Pexa is a cop. Cristhian Bahena, in his statement, was taking care of his own. He was protecting his daughter and his daughter's mother. But let's talk about 460th Avenue. 460th Avenue, I would submit to you, was not just some random place. Ron Pexa's house is on there. Now, whether or not he had anything to do with it, we don't know. What we do know is that people were calling in with tips that he was some sort of sexual deviant. It was known. Okay? What we also know is that officers met with Darian Davis, who was mowing that cemetery on 460th Street. We know that Darian Davis associates with Jackson Eichhorn. The testimony was that Jackson Eichhorn was in the cemetery in Brooklyn, and one of his stories was he was helping Darian Davis mow at the time Mollie Tibbetts was jogging that night. Ironic that this guy happens to be mowing two different cemeteries, both where Mollie Tibbetts is associated. I don't think so. Not saying Mr. Davis has anything to do with it, but people knew those two cemeteries were connected. 460th Avenue is not a coincidence. And the 2384, again, less than a mile from where Mollie was found, 4 buckle swabs, just on the other side of Ron Pexa's house, were taken by Agent Bublitz at the FBI direction and never tested. The route taken by Cristhian Bahena after Mollie was abducted was straight down 200th Street, a hard left, and then down through this 430-foot driveway and through long grass to this cornfield. This man had no idea where he was going. That route was direct, 5 or 6 miles south, 2.5 miles east, then 110 yards in. That is not coincidence. He would have no idea where this was. He was directed to go there. We think Christian's confession or his statement was inaccurate. It was false. You see here, he fell asleep 3 different times. Once more, he's getting pressed. Falls asleep again, getting pressed after hours and hours. It was an 11-hour interrogation. He was isolated from his family. He was driven to the sheriff's office and not allowed to bring his own vehicle. Police indicated that confessing might lead to a more lenient sentence. Help yourself, Christian. Police firmly
I'm
stated.
going to object. That's not the evidence of the case. I don't believe there's been anybody testifying to that.
Client did, Your Honor.
Overruled. Go ahead. Proceed, Mr.
Our client said very clearly that they said, help yourself. Police firmly stated that the evidence against Christian was overwhelming Therefore, resistance was futile. He was deliberately picked up at the end of the day and deliberately interrogated during the time where he would have been sleeping. They lied to him. They employed trickery or dishonesty. They said, "We're not here from immigration," and they called immigration. They suggested psychological excuses for the offense. That's where the blackout comes. They took steps to enhance their authority while interrogating the suspect. That's where Trent Valletta gets right in his face. They put 3 people in his space. They made Christian think that 1 or more interrogators were Christian's friends and were trying to help him or her, or him in this case. Character evidence. You heard a lot of people talking about Cristhian Bahena. His cousin bought him a car. He paid it on time, first of the month. People said he was not a violent person. This would not be like him. He didn't want to be detected. He just wanted to take care of his family, take care of his daughter, work hard. This makes no sense. Every one of those people who testified were credible, they were believable, and buttressed everything this man said in his credible testimony. If the evidence of such good character as to nonviolence is good enough, together with all the other evidence to raise a reasonable doubt as to his guilt, he must be acquitted. If these people's testimony is that believable, and I submit it is, you must acquit him when you couple that with their lack of evidence. Folks, that's the verdict form you're going to get. The judges instructed you on the how to deliberate and what your verdict must be. We submit it should be not guilty. So remember, that man right there is the one you have to judge. That man. The father, the son, the man who come here to make a better life for those around him. He's not a monster. You saw him testify. You saw him credibly testify. This case was closed. This case is police logic 101. Okay? Police logic 101 is opposite of the analysis that you have to do. The analysis you have to do is you take all the evidence that you've heard and you boil it down and you determine if that evidence produces guilt beyond a reasonable doubt. That's not what the police did. What the police did is they had 4 weeks of nothing, and then they picked this man. And who better to pick than an undocumented immigrant who doesn't speak the language, who has nobody here to speak of to help him out. And then you cherry pick the facts that fit your theory, and you close the case. Case closed. But the case is not solved. Folks, there is serious doubt in this case. Serious doubt. Cristhian Bahena Rivera has not had the case against him proven beyond a reasonable doubt. And the only verdict that you can come up with under these facts and what you heard right there is not guilty. Thank you.
Jury, Mr. Bahena, and the attorneys of record are all present. Mr. Freeze, at this time, you may give your closing on behalf of Mr. Bahena.
Thank you, Your Honor. May it please the court.
Counsel.
Mr. Brown, Mr. Klaver. Good morning. Everyone hear me okay? Good? Okay. If you can't, give me a wave, do something, get my attention. We have the construction again, and I have the microphone kind of near me, so if I need to raise my voice, I will. I won't be yelling at you. I'll just be trying to project and trying to get your attention. All right, where to begin? Let me start by, I guess, saying that I would be remiss if I didn't just take a moment to say thank you, okay? Thank you for your time. Time is your most precious and valuable resource. It's all we have. Okay, so one thing you can spend, but you can never buy, never get any more of it. It's the most valuable thing you can give somebody is giving them your time, being on time, your time and attention.
That tall, totally inconsistent with that. Ulysses Felix, where is he?
And says, I'll take you there. Their conduct, what interest they have in the trial, what's their shrunk, right? We would expect that, especially if he was involved with killing. He knew the defendant and been to his house overnight.
Sustained, Mr. Freeze.
But we asked, and then down to this 430-foot driveway into long grass to this cornfield.
Members of the jury, here's what we're going to do. We are not going to take a formal break. It has been a while since we've had a break. I'm just going to give anyone an opportunity, if they would like at this point, please stand up and stretch.
Worked every angle, worked every lead. There's pressure to close any case whenever they have somebody, particularly like Mollie Tibbetts or any other person who's been the victim of a violent crime. But the pressure to close the case doesn't mean they go out and create their own evidence. If that were true, why wouldn't they just go ahead and do that right at the beginning? Go point the finger at somebody else. Do something, create something, plant something. That's not what they did, right? They go and chase the leads. They look at Mollie's inner circle, right? They look at Dalton. They look at people who know her. They search 622 West Des Moines. They're looking for signs of violence, signs of breaking and entering, things of that nature. They don't find it, right? They're trying to shake this tree as hard as they can to see if there's any leads that fall, and there's not. Until when? Until they get the video, right? That's the lead that breaks this case. They follow it. They find the defendant, right? They bring him in. He makes the admissions he makes. The blood is in the trunk. What are the officers supposed to do? Start looking at Ron Pexa? Start going out and just checking other people to see if maybe, they had something to say about it? I mean, come on. The officers in this case, the agents in this case, the deputy sheriffs, the FBI agents, all of the people who were involved followed the evidence, and that's what we're asking you to do. The defendant was not targeted. That's a word that Mr. Freeze used. The defendant here was not targeted, all right? The evidence led officers to him. The video evidence led officers to Cristhian Bahena Rivera. They didn't target him. He targeted himself by becoming involved in this. No knife. I think he's mentioning this from 622 West Des Moines and the weapons. It's not a crime scene. And by the way, there's no evidence that Blake Jack or Dalton Jack are involved. Goodness, they ran Dalton Jack to the ground in this case. They interviewed him multiple times. They looked at him, right? They found out what his history was, what his that he'd had this brief fling with another girl named Jordan. And by the way, when you're 18 years old, it's not like I've been married 32 years and I got 3 kids. Okay, that'd be a lot different. Let me tell you. Okay, but he's a kid, right? What do you do if you're not getting along with your girlfriend? You break up with her, right? You don't take her out in the country and stab her to death. Does that make sense to you? Goodness. The primary crime scene, you don't know. Well, guess who had control of that? This guy. All right, who's got control of the Malibu for almost 4+ weeks? The defendant. Right? He's got control of Mollie Tibbetts. He controls where she went. He controls where her body got dumped. He controls what the physical evidence is in his trunk. He does. The reason why we don't have whatever a primary crime scene is because of the defendant. You have to factor that in. Motive. He's not angry. Are you serious? He told us he was angry. The words came from his mouth. The defendant is a yes man. Not yesterday, he wasn't. He gave you a whole new story. Mr. Freeze touched on that, about Iris Gamboa, about his daughter, about all of those things. We'll talk about that here in just a second. But he's not a yes man yesterday. That's for sure. So tell law enforcement then about these other two men, right? So you're in a place where you can be protected. So tell them. I mean, you have multiple officers at the Powashik County Sheriff's Office. You're probably one of the most secure places in the county. You know, he's there with law enforcement. He could ask for help. All he has to say is, okay, listen, guys, I think I know what happened. There's these other two guys, these other masked men that are covered, that were in my house, right? I don't really know who they are. I'm scared for my daughter. I'm scared for Iris. Can you please help me? If you help me, if you get them here, I'll tell you what I know. But he didn't do that. You know why? Because it didn't happen. Why use Pamela Romero? Let me tell you what the flip side of this would be. So let's say officers went in, like the picture that you saw, with Agent Valletta and the FBI agent, neither speak Spanish. Or we have somebody else, there was a mention of Jeff Fink, who was a officer from Iowa City, who's not a native speaker. So let's say we try, Officer Romero, you're just not experienced enough, okay? By the way, you saw her testify. She's an impressive young woman, right? I mean, she did a phenomenal job in recounting what the defendant said. The whole interview is in Spanish, but why not take advantage of a native speaker? Why not do that? Then we have a clean conversation. It's not going through an interpreter. You know, there's none of that. You have it, and she can then come out and say, this is what he said. That's why we didn't show you the video. It's in Spanish. Doesn't that make sense? If we had used Officer Fink, or if we had used Agent Valletta, then it would be, oh, hey, wait a second. Didn't they have a native speaker right there? Why not use Officer Romero? We know she's not experienced, but why not use her? The flip would just be true. But the officers chose to use the native speaker that knew Spanish, that was her first language, so she could understand what the defendant was telling her and relay that to investigators. You know, he wasn't so worn down that he couldn't lead them to Mollie Tibbetts. That's true. Yeah, he does. They give him rest, by the way. I think Officer Romero talks about 9 times that they took breaks during the day. So it's not like an 11-hour interview where he's got somebody in his grill the whole night. I mean, he's sitting there at a table. He does get a chance to take a break. He gets a chance to eat. They're good to him in that sense. They are asking him hard questions, which I would hope officers would do under these circumstances. Dalton Jack, listen, Dalton Jack was in Dubuque, okay? He was working there actually the day before. I think he was in Iowa County working. That's what his boss said this morning. But Dalton Jack is in Dubuque. You know, phone records, people put in there. By the way, if he's off at 7, right, how's he going to get back to do anything? And he's going to have to, what, take Cristhian Rivera's car if somebody has no idea, and what, go and chase down Mollie where he doesn't know where she is, and what, he's going to teleport himself back here in, you know, less than an hour? I mean, it's over a 2-hour drive from where he was working to here. Plus, he had no reason. No reason. If the defendant's DNA is in his trunk, the response is, of course it is. If we would have found Cristhian Rivera's DNA in the trunk, of course it is. It's his car. It's a push. It's like the fingerprints that they talked about a little bit later. You know, people can touch things and fingerprints can be there. It was on items that were in the trunk. The fingerprint expert doesn't know where they come from, doesn't know how they got there. They're not associated other than being in the trunk. They could also be Mollie Tibbetts', by the way. Remember, hers are so destroyed that because she was decomposed. And then, so it means nothing. You know, all these things that Mr. Freeze brings up have to matter, right? He's poking holes, punching at our case, you know, telling you these things. But whenever you sit back there, if you evaluate them, they have to matter. Ron Pexa is 6'7". He doesn't describe the men in his house that tall. Totally inconsistent with that. Ulysses Felix, where is he? There's no evidence that he's associated with Ron Pexa or Dalton Jack or anybody else that they're throwing stones at over here with regard to who may be involved. There is no false confession, for goodness sakes. If the defendant falsely confesses, how does he take them to Mollie Tibbetts? He knows where she's at. It's the one piece of evidence in this case, the one circumstance that completely cuts that argument down to the ground. So motive. There was another motive here, a sexual one that we know about, that we can look at. This is the document that shows the crime scene diagram. Mollie Tibbetts' body, if you recall, her legs were spread apart and her knees were up and her underwear and her shorts were off. They were at a different spot. Her jogging bra is pushed up to around her neck. All right. The defendant says that he left her with her clothes on. That is clearly not true. The defendant says, before we get to that, he also says in his interview that she is hot or attractive. The way that it was interpreted by Romero was that the Mollie Tibbetts, that he said that she was hot. That's why he was encountering her, because he found her attractive. That's why he chased her down. That's why he stopped on the road, right? He saw a pretty girl and it drew his attention. Mollie is found with no shorts or underwear. Her jogging bra, like I said, is pushed up around her neck and her legs are spread apart. That would all suggest a sexual motive here. Guess who does not have a sexual motive? Dalton Jack or anyone else that's been erased here by the defense. The defendant wanted to encounter Mollie Tibbetts by his own admission because he said that she was hot or attractive. And we have physical evidence at the scene that would suggest that there is also a sexual motive here that corroborates the defendant's involvement. She was found in that condition under the corn stalks, and he testified that she was clothed. That's what he said, but we know that's not true. Look at the corn stalks. They're not disturbed. Look at it. There they are. The corn stalks don't appear to have been disturbed. His testimony cannot be true based upon the evidence near Mollie. So, which means the sexual motive is there, that her clothes were off, that he took them off, that he was there by his own admission, and we have physical evidence at the scene of the clothes being off and the corn stalks not being disturbed. It all provides another reason, which excludes other people. So why consider it, again, I've mentioned this already, why consider a sexual motive here? There's another circumstance, that removes Dalton Jack, who they pointed the finger at repeatedly in this case, or anyone associated with him. It also excludes the two phantom men story. By the defendant's own admission, there was no sexual motive there. There was no evidence of that. So these two phantom men that show up at his apartment that he can't identify, exclude it, right? I mean, it supports it. It supports the sexual motive. These guys didn't have that. Dalton Jack didn't have that. It's consistent with the defendant's statement to Pamela Romero that he found her attractive, that he had found her hot. That's why he encountered her on the roadside. All right, the defendant's testimony here is unbelievable. Mr. Freeze has touched on some of this with regard to Iris Gamboa, to the daughter. Let's look at that. Why would he create a new story? Okay, why would he do that? He had an opportunity, by the way, to sit here in this case, to view the evidence, to think about the evidence. He knows DNA puts Mollie in the trunk of his vehicle. He now knows that. He did not know that at the time of the interview with Pamela Romero. He now knows multiple videos place him near Mollie within seconds of running through the area whenever she was on boundary. We see his car within about 25 or 30 seconds after that. He knows after sitting through all this evidence, he's under a pretty big rock, right? And he's got to come up with something else. He's got to come up with a story to describe or explain away why he led the officers to the body, right? So what's he come up with? What's the context of this? He's now seen all the evidence against him. His statement with Romero ended with him charged with murder, right? He tried to give them a story. He told them what happened, right? Which is a lot closer to the truth. But now he knows that got him charged. He finds out later, as Mr. Freeze pointed out, that the DNA didn't come in until later, that it is all that Mollie's blood is in the trunk. He has had access to all the evidence in this case. He's had access to the video. He knows his car puts him there. So he knows all that. That's the context here that we're dealing with. The defendant's testimony that two men killed Mollie is totally unsupported by any other evidence in the case. Totally. He says that the two men that showed up at his house or his trailer are covered head to toe. He can't ID them, right? He covers them completely. This is the middle of July, right? And he says they're in sweaters and pants with stocking hats that cover their face. He can't identify them, right? Is that believable? The other thing that might identify these men is the vehicle that they were driving. He never puts them in a car. They just randomly select him out of thin air. They appear out of nowhere to select him as the person. And then what? They hang out at the trailer for a while. He's not real specific about that. And then not only do they appear out of nowhere, then they vanish into thin air once they get out to the field. And he can't identify them. It's simply not believable. These phantom men, think about this, leave the only eyewitness to a murder. They are attacking Mollie Tibbetts on the road. That's what he said to you whenever he testified. And they stabbed her and they put her in the trunk. Why not kill him? Why not take him out? There's no connection between these two. They leave the only eyewitness with a vehicle, according to him. They leave, these phantom men, leave him with a cell phone. That's what he said. Actually, two. I think he says Mollie's cell phone is in the trunk as well. So they just vanish out of thin air, walk away in a cornfield after killing this young woman, and they leave him with transportation and a cell phone. That makes no sense at all. Why would they do that? Why would they even involve him? Why not just take out Cristhian Bahena Rivera right there with Mollie? They've got a gun, they've got a knife, take him out. Pile his body into the cornfield. Why not do that? Why do they need him in the first place? It makes no sense. He's not thinking about that. You know why it doesn't make sense? Because it's not true. It's not true. He conveniently throws in the name Jack. Did you catch that yesterday whenever he was testifying? He spent parts, or he's back, one of the guys I think is in the back seat, and one of the guys says, "Come on, Jack." Really, so the one guy that they're pointing the finger at, the chief one, happens to have that last name. He throws that in. You got to ask yourself if that makes any sense at all, or is he just trying to point the finger at Dalton Jack to say that's who it was that was there and that took Mollie on the roadside? They have spent parts of 2 days in this trial trying to identify Dalton Jack as the person with the motive and the opportunity to kill Mollie. Dalton Jack is alibi, ladies and gentlemen. He did not do this. He didn't. He's working in Dubuque. I mean, so now his boss is going to come in here and make up records and not be truthful with you for what? Why would he do that? Why? I mean, Dalton Jack is alibi. He's working on a bridge. He got off at 7. He went back to the motel. He grilled with his co-workers. Dalton Jack is alibi. Dalton Jack did not do this. If other men killed Mollie, which is what the defense has put on here, what purpose would it serve then to include the following statements here? We've already talked about this in my first close, but what would it serve to include the following in these statements to the police? That Mollie had rebuked him, that Mollie didn't want anything to do with him, that Mollie had threatened to call the police, and that he was angry. How does that fit in with what he claims is the real narrative, that these two unknown men that were masked grabbed her and made him take her to the cornfield? It doesn't fit. There's no reason to offer it. He's trying to offer a reason to the officers as to why that happened. These statements only fit with nobody else present and with what the evidence was whenever he testified first, that there were not two other men in the car and that he acted alone. There is no evidence here that he told Iris Gamboa anything about a threat, right? He testified here the reason why he didn't tell the officers about the two men that came to his trailer that he can't identify is because they had threatened Iris and they had threatened his daughter. But he doesn't. Iris Gamboa testified. Did you hear any testimony from her? She's called by the defense. Any testimony from her that, oh yeah, he told me what happened. He was fearful for my safety. He was fearful for our daughter's safety. He didn't say a word about it. There's no evidence in this case that he took any steps to protect his child or Iris. Iris never testified about a threat. So ask yourself why. And my suggestion is it didn't happen. There was no threat. There were no two men. He's made these men up. He's trying to get out from underneath that very big rock. He had a chance in this case to tell the police about the two men. He chose not to do that. If you're taking any of his statements as true that he testified to yesterday. The sheriff's office is a well-protected place. He had a chance to tell the officers that. He was even encouraged multiple times by Officer Romero. Is there more? Is there more? Right? She keeps coming back to him. Right? He has plenty of opportunity to do it, and he chooses not to do that. Why did he choose not to do that? He claims to protect his daughter and his girlfriend, who he had his daughter with. The best place to get that protection would be from the police. And he didn't do it. You know why he didn't do it? Because it did not happen that way. That's what it proves. All right. These are the elements of murder in the first degree. Each of these elements has been proven beyond a reasonable doubt. All of the evidence here points to one person, and that is the defendant, Cristhian Bahena Rivera. No one else had a reason to kill Mollie Tibbetts. His reason is not a good one, like I said before. When would it ever be a good idea, or you would ever have a good reason to kill somebody in this way? But that's what happened, and he told us that's what happened. He was angry, he was rejected, and he got angry at her, and he killed her over it. That's what cost Mollie Tibbetts her life. The video, the confession, and the physical evidence in this case tell the story. There should be no reasonable doubt in your mind. Looking at all this evidence, you must be firmly convinced. I would encourage you to use your common sense. Look at this case, judge it with your backgrounds, look at it, evaluate it. We welcome that. Use your common sense whenever you look at this. And at the end of the day, right, at the end of all of that, ask yourself, are you firmly convinced? Are you firmly convinced that Cristhian Bahena Rivera murdered Mollie Tibbetts? The evidence in this case, there's a mountain of it. It is overwhelming. And it leads you to the only conclusion. You follow it down the path. All of the evidence in this case. Cristhian Bahena Rivera took this young woman's life. This is Mollie. He took her. He committed the murder. Why? Why would this happen? Because he's angry? Because he wants to have some sort of relationship with her? Because he finds her hot or attractive? Goodness. That's what happened. Mollie's no longer on this planet because of the defendant. All of the evidence here points to one verdict. The defendant, Cristhian Bahena Rivera, is guilty of murder in the first degree. That's what your verdict should be after your deliberations in this case. Cristhian Bahena Rivera is guilty of the first degree murder of Mollie Tibbetts. That is your verdict. Thank you.
Thank you, Mr. Brown. Good afternoon. We are on the record in the presence of the jury. Mr. Bahena is present along with the attorneys of record. Juror number 2. Do I understand correctly, you were selected as the foreperson in the case?
That's correct.
And Mr. Foreperson, has the jury reached a verdict?
Yes, sir.
And is the verdict unanimous?
Correct.
And has the foreperson, have you signed the verdict form and marked it in accordance with the verdict? With that record then, sir, I would ask that you hand the verdict to the court attendant, please. At this time, Mr. Bahena, I'm going to ask that you rise along with your attorneys, please. And I would ask that the court attendant read the jury's verdict.
We, the jury, find the defendant, Cristhian Bahena Rivera, guilty of the crime of murder in the first degree.
Thank you, Carrie. You may be seated, please. Juror number 1, for the record, is this your true and accurate verdict?
Yes.
Juror number 2, is this your true and accurate verdict?
Yes.
Juror number 4, is this your true and accurate verdict?
Yes.
Juror number 6, is this your true and accurate verdict?
Yes.
Juror number 8, is this your true and accurate verdict?
Yes.
Juror number 10, is this your true and accurate verdict? Juror number 14, is this your true and accurate verdict?
Yes.
Juror number 19, is this your true and accurate verdict?
Yes.
Juror number 30, is this your true and accurate verdict?
Yes.
Juror number 32, is this your true and accurate verdict? Juror number 38, is this your true and accurate verdict?
Yes.
Juror number 48, is this your true and accurate verdict?
Yes.
Before I release the verdict, anything else on the record in front of the jury? Mr. Brown?
No, Your Honor.
Freezes?
No, Your Honor.
Thank you very much. On behalf of the state of Iowa, this completes your service. Carrie will take you back to your jury room. Thank you. Please be seated. We're still on the record. Outside now, the presence of the jury. Mr. Bahena is present along with the attorneys of record. The court has three things it wants to address and see if there's anything else we need to. Number one, we will order a pre-sentence investigation report to be prepared and submitted by the extrajudicial district. Number two, no bond pending sentencing. And three, sentencing will take place at 9:30 a.m. July 15th, 2021. Sentencing will take place in Montezuma, Iowa. Mr. Brown, from the state of Iowa, anything else we need to address on the record?
Nothing further, Your Honor.
Freezes, anything else?
No, Your Honor.
With that, then, we will close the record. Thank you.
Okay, you want to start asking a question, Lloyd?
Fire away.
Give us your reaction to this verdict.
We're disappointed. We respect the jury's verdict. They took a lot of time to come to the verdict. We wish it would have been different, of course, but they certainly came to their decision. We respect that decision. We'll explore our options now post-trial and go from there.
How difficult of a case was this from a defense perspective, considering he admitted to having Mollie Tibbetts' body in his truck and the DNA was there?
Very difficult, of course. I mean, anytime you have a client who gives a statement like he did, and the fact that there was DNA evidence in the trunk, and the fact that he led them to the body, I mean, it makes it extraordinarily difficult. Absolutely.
Considering the statewide attention to this, are you, I'm trying to think of how to put this, but are you convinced that it was ever possible to find a jury? Do you believe they were impartial here?
In this case, we're very pleased that the jury took the time that they did to look at the evidence and to deliberate in this case. You know, it would be impossible to find a jury that hadn't heard about this case, and that wouldn't matter even if we had the ability to leave the state of Iowa. We would, which we don't, but we wouldn't be able to find someone, a group of people that haven't heard from this case. We're really pleased with the time that has been spent with jury selection and the time that was given to this case. So we're disappointed with the outcome, but that's what it is.
What are those potential options for you that you're mulling at this point?
Well, of course, we'll look at post-trial motions. We'll go back and look at any evidentiary issues that were raised during the trial. And of course, we had that issue on the motion to suppress that was litigated prior to trial. And of course, that'll be looked at on appeal.
It's no secret that we disagreed with Judge Yates's suppression ruling. We sought discretionary review with the Supreme Court, and the Supreme Court denied that. Because we will file an appeal on Mr. Bahena's behalf, the Supreme Court will have the opportunity to review those claims and to make a decision.
Do you have an estimate on how long it will take to file that appeal?
Well, the sentencing's on July 15. So we have 30 days from that day. So you're looking at end of July, first part of August.
Can you talk us through the decision to have your client testify?
Well, the decision to have him testify wasn't as difficult as a lot of people want to make it sound. I mean, we had a situation where a client gave a statement, and he had her DNA in the trunk, and he led him to the body. That's all pretty incriminating evidence. And from the very first day we met Mr. Bahena, the story he put forth on the stand was exactly the version of the events he told us going back to August 2018. He had never varied from that version of the events, not one detail. So we had to get something up there, and we thought the jury needed to hear directly from him, especially since they couldn't judge the credibility of him on the video since it was in Spanish. And we had real issues with that interview and how it was conducted. So it really wasn't that difficult of a decision for us.
To clarify, did you say that the account that he gave on stand is the account that he gave to you in 2018?
Absolutely. He has never varied from that, not one detail.
You know, I think there was speculation that we made some sort of, let's figure out a story. And I mean, if we were going to make something up, we would have came up with something better than that.
Do you worry that it didn't sound credible to the jury?
You know, that just the story of Mollie Tibbetts' abduction was a bizarre story in and of itself. So what we thought is that whoever told the tale, whatever tale it was, had to sound credible. And the version of the events given by Mr. Bahena, it had to sound credible coming out of his mouth, whatever it was. So we were more concerned about how he appeared to a jury and how he sounded to a jury. And we didn't spend a whole lot of time preparing him. We wanted him to seem authentic rather than coached. And so we didn't spend, an inordinate amount of time preparing him to testify. We kind of just let him tell his story in a very genuine fashion. So what you saw from him yesterday is really who he is.
One thing that we can agree, and I think everybody can agree on, is that Ms. Tibbetts was someone that did not deserve to be a victim. And the fact that this woman went out for a run and ended up in this cornfield is just bizarre on its own. You know, she was not the type of person that would engage somebody in an argument. She's not the type of person that would be hurtful. I think that her choice, even if she thought something bad, would be to be kind. And it doesn't, I think any reason that someone would abduct her and leave her dead in a cornfield is just a bizarre set of facts, no matter what.
You worked throughout the case, or the trial, pointing fingers towards Mr. Jack's boyfriend. Is that, in your mind, the most likely?
He certainly gave us reason to suspect. Okay. There's a lot of people in this case whose stories didn't check out well enough for us. And that was a problem for us. So can we tell you who did this? No. We can tell you that getting to know Cristhian Bahena, we are very surprised that he would be the kind of person that would commit a crime like this. He is nothing but a soft-spoken, respectful, kind person. And every person we have talked to in the last 2.5 years who has had any interaction with this man echoes that. He's been a delight to represent from a legal standpoint, from a lawyer standpoint. Has been absolutely no problem.
And another thing I'd point out is his family has been just a delight to work with. I know that there has been some questions from some of you about whether or not his family or why they haven't been at trial. These people are hardworking people. And I will tell you that whenever we meet with the family, we normally have 7 or 8 people in the room that care for him. And these are all people that work hard and have been following this case very closely. The fact that you all have been able to provide this to the public so easily has been beneficial. That this family, they just don't have the resources to take off 2 weeks, but they've been watching closely. We'll be in touch with them as soon as we leave the courthouse. And it has been a pleasure to work with the Bahena family. I have no unkind things to say about any of them, similar to how we feel about the Tibbetts family.
It sounds like you're intending to remain his attorneys as he goes through the appeal process. Is there any thought at this point to bring on any additional lawyers to the team?
Not at this point.
You mentioned during the trial when you were, I believe, cross-examining or examining Dalton Jack about phone records. Those, to my under recollection, weren't introduced as evidence. Did you have those records? Were you planning on introducing them? If so, why not?
Well, there's evidentiary issues as far as the rules of evidence that don't allow you just to introduce phone records. We did have those phone records. They were about 5,000 pages in length. What we wanted to use them for more than anything was to point out inconsistencies in his story, or stories, I should say, and how it was just kind of a head scratcher to us, how he could not recollect the days leading up to his girlfriend's homicide. And that was a problem for us.
Also during your case, you mentioned the unknown DNA, the unknown fingerprints. Are there plans, or are you able to independently test any of that on appeal?
The problem is if we don't have a buccal swab from somebody, it's pretty difficult to do that. There are times that, there's databases that certain people, that are compelled to give a DNA sample. But, if my DNA were in something, or probably yours, it just isn't going to be there. And with this case, again, with the Tibbetts family and with the Jack family, I don't think we have any reason to believe that unless, we had their buccal swab, that it would show up on some sort of a database.
Is there any other evidence that you wish that you could have brought out in the case that, or that maybe you were on the fence about bringing out? What were some of the considerations there?
Oh, go back and look at our motion in limine. And I think you can tell from that. I'm not going to speak any more on that today. But look at our motion we filed right before the case was heard. Our resistance to the motion in limine, I think, will speak for itself as to what we would like to have introduced. There's been other motions filed throughout the case that talked about other evidence that you didn't hear in trial, but I think speaks to perhaps why we were so intent on going after one witness in particular, Mr. Jack.
What about the two masked men? Were efforts ever made to locate them?
It's like trying to prove there's not a Santa Claus. I mean, we don't know who those persons could be. Remember, our client lives really out in the middle of a very rural location. And we kind of tried to link it up the best we could through the people who we thought would have some sort of motive. And that's where we went with some of the testimony, but that's very difficult to establish.
We're fast approaching 3 years since this happened. Do you think timing of this trial played a part in some of the witness testimony and the verdict today?
A little bit. I think it also helped as far as 2018 was a much different time than we have today. 2018 was, in my opinion, very conflictual, very difficult time for an immigrant. If we'd have gone to trial within 90 days, like a speedy trial right would have allowed him to have, I think it would have been very difficult for him. I think the passage of time has allowed some of the pain to heal a little bit, let all of us kind of just take a breath and be a little more pragmatic in our decision making.
We don't want to keep the family and everybody. So maybe one more question.
They said, 10, 15 minutes.
Okay.
Can you explain, Mr. Bahena's, status as far as citizenship or immigration, or how the status, is he staying in the country until appeals are exhausted, or do you have a sense of that?
He'll serve whatever sentence he receives, and then they'll take care of that issue.
You good?
All right. Thanks, guys.
Thank you.
You bet.
Thank you.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. solving more than just trivial quests, where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.